Modification Awards. Yeah, it's a
डिस्प्ले में रिजोल्यूशन सेट करोगे हाँ सर्च करो यार डिस्प्ले मेरा अच्छे रिजोल्यूशन पास वॉलपेपर सेटिंग्स के साथ पासवर्ड need શું હોય છે આમ તો રિઝોલ્યુશન લખો ને એકવાર પીડીએફમાં તો એવું નહીં થાય ને પીપીટી તો
આ હેડ કેટલા
ઓકે એ જ કપાય છે ને ખાલી ચાલશે પણ એ કોઈ નહીં દેખાય
અહીંયા રાખવું છે બાય ડિફોલ્ટ રાખી દઈએ ને
પછી ચેન્જ કરશે રિઝોલ્યુશન તો આમાં કપાઈ જશે પછી
રિઝોલ્યુશન ચેન્જ નથી કર્યું એટલે આ જે છે ને આ થાય છે અત્યારે
પણ એ તો એ તો કેવું છે કે વોલપેપરનો સાઇઝ થી પેલું રિસાઇઝ કર્યું છે ભાઈ રિસાઇઝ કરેલું કેવું કે આ ડિસ્પ્લે રિઝોલ્યુશન પ્રમાણે આવવું જોઈએ પણ એમાં ઓનલાઈન કર્યું એટલે થોડું ઘણો ચેન્જીસ
Good morning, everyone. We'll commence the conference shortly. Thank you for your patience. A very good morning to one and all. I, Gargi Vyas, with my colleague Jay Kansara, take this opportunity to welcome you all to a two-day conference organized by the Gujarat High Court in collaboration with Gujarat State Judicial Academy on the subject of arbitration and its many facets, a subject which is contemporary and ever-evolving.
Gives us immense pleasure in welcoming our distinguished panelists as well as the participants for this conference, which is probably a first of its kind in the state, both in scale and spectrum, and hopefully one of the many to come in future. Please join us in welcoming the dignitaries on dais, who otherwise need no introduction. It is our absolute privilege and honor to welcome Honorable Mr. Justice N.V. Anjaria, Judge, Supreme Court of India, Honorable the Chief Justice, Srimati Sunita Agarwal, the three senior judges of our High Court, Honorable Mr. Justice A.Y. Kokje, Honorable Mr. Justice A.S. Supaya, and Honorable Mr. Justice Bhargav Karya.
We now request Honorable Registrar General Shri Sanjay Suthar and Honorable Director of the State Judicial Academy to proceed with felicitation. Nuances, please. But before that, honorable dignitaries on the dais and off the dais, honorable judges of the District Judiciary, learned Advocate General, learned Additional Advocate General, learned Government Pleader, learned Public Prosecutor, and fellow advocates, a very warm welcome to one and all. Over the course of this conference, we shall witness participation by distinguished jurists on the subject who've not only seen the law evolve up close, but have also played a pivotal role in shaping the jurisprudence as it stands today. A session which we all hope would intellectually stimulate the stakeholders and provide a conceptual clarity on the elementary yet intricate level on the subject of arbitration. We extend our sincere gratitude to all the honorable dignitaries and panelists for taking out time from their otherwise busy schedule to share with us their invaluable insight on the subject.
May we now request the honorable dignitaries on dais to come forward for watering of saplings, which is otherwise more than a ritual for us, which symbolizes nurturing growth, fostering new ideas, and leaving behind a legacy that will continue to grow. And above all, it reflects our shared responsibility towards the sustainability and harmony with the nature. Obliged, your lordships. May we now request Honorable the Chief Justice to give the welcome address to this gathering.
Honorable Mr. Justice Nilay Vipinchand Anjaria, Judge, Supreme Court of India, my esteemed brothers on the dais, Mr. Justice A.Y. Kokje, Mr. Justice A.S. Supaya, Judges, High Court of Gujarat, Mr. Justice Bhargav D. Karya, Judge, High Court of Gujarat, and President, Board of Governors of the Gujarat State Judicial Academy. My brother and sister judges of the High Court of Gujarat, Justice Hima Kohli, former Judge, Supreme Court of India, who will soon join us, Justice Girish S. Kulkarni, Judge, Bombay High Court, Justice Sabyasachi Bhattacharya, Judge, Calcutta High Court, Mr. Darius Khambata, former Advocate General of Maharashtra and Additional Solicitor General of India, Mr. Gaurav Banerjee, former Additional Solicitor General of India, Mr. Ritin Rai, Senior Advocate, Supreme Court of India, Mr. Kamal Trivedi, learned Advocate General, Ms. Manisha Lavkumar, Learned Additional Advocate General, Mr. Mitesh Amin, Learned Additional Advocate General, Mr. Gursharan Singh H. Virk, Government Pleader, Mr. Hardik Dave, Public Prosecutor. Learned Senior Advocates, participating officers of the District Judiciary, young lawyers of the District Judiciary and the High Court, the Registrar General and officers of the Registry, the Director Gujarat State Judicial Academy and his team of judicial officers, participants joining virtually, distinguished guests, ladies and gentlemen, good morning and namaskar. It is an absolute pleasure to welcome you all at this two-day conference on arbitration law. This conference marks an important milestone in advancing arbitration in the state of Gujarat. This event reinforces the commitment of the High Court of Gujarat to strengthen the system of dispute resolution outside the traditional courts by engaging with all the stakeholders through capacity building programs. We are deeply honored to welcome Honorable Mr. Justice N.V. Anjaria, Judge Supreme Court of India, as the chief guest of this conference, who is one of us, a distinguished jurist whose journey began in the corridors of the High Court of Gujarat. His elevation to the highest court of the country serves as an enduring inspiration to all of us. Hailing from Mandavi in Kutch, born in Ahmedabad in 1965, his lordship comes from a distinguished family of lawyers and judges. After completing his studies at H.L. College of Commerce and Sir L.A. Shah Law College, followed by a Master of Laws from the University School of Law, Ahmedabad, Justice Anjaria embarked on his legal career in the year 1988. Since his formative years, his lordship distinguished himself across constitutional, service, civil and labor matters, serving as standing counsel for key public institutions. Having a knack for writing, his lordship served as associate editor of the Gujarat Law Herald, authored numerous articles and write-ups on constitutional and legal subjects published in reputed books and journals, and contributed a seminal piece titled High Court of Gujarat, Advent and Ascent in the Souvenir, published on the occasion of the High Court's Golden Jubilee in April 2010. His Lordship's judgments as a judge of the High Court of Gujarat reflected a judicial craft that truly stood apart, marked by precision, balance, and a vision that set a benchmark of judicial excellence. In a notable case of Thakur Hiraji Sakhaji versus State of Gujarat, His Lordship upheld the ban on poppy capsules, observing that the right to life under Article 21 encompasses a healthy and orderly existence harmonized with the broader public good. His Lordship was elevated as the Chief Justice of the High Court of Karnataka on 25th February 2024, where His Lordship's tenure was marked by significant rulings balancing constitutional principles with pragmatic outcomes. The judgments of His Lordship reflected not only a keen sense of justice for people, but also a deep sensitivity to the protection of wildlife. Confronted with elephant death from sagging power lines and unsafe fences, including the tragic Lord of Elephant Ashwathama, His Lordship recognized a systematic failure and directed measures to protect wildlife. These directions seek to safeguard elephants and affirm that their welfare is essential to balance the ecosystem. His Lordship's elevation to the Supreme Court of India on 30th May 2025 stands as a testament not only to his exceptional legal acumen, but also to his commitment to integrity, fairness, and justice. Today, as we welcome Justice Anjaria to the precincts of the High Court of Gujarat, this gathering marks his homecoming, making it both historic and symbolic. His Lordship's presence in this hall is truly inspiring for all of us, especially the participating young lawyers and judges. This conference is designed for the district judiciary and the members of legal fraternity, including lawyers practicing in district courts, with the idea to strengthen them so that disputes can be resolved effectively at the grassroots levels. The majority of litigants in India first engage with the justice delivery system at the district level. It is here in the trial courts that the justice system truly meets the citizens of the state. If arbitration, mediation, and hybrid modules of dispute resolutions are to succeed in the state and in our country, their strength must be felt not only in the metropolitan centers, but also in every district and every taluka court. This gathering is further truly elevated by the presence of legal luminaries whose I would welcome Justice Hima Kohli, former Judge, Supreme Court of India. Ma'am, you are most welcome in this gathering. This gathering is further elevated by the presence of legal luminaries whose wisdom and experience will shape the discussion at this conference. We have the wisdom and experience of Honorable Justice Hima Kohli, former judge of the Supreme Court of India, who has been a strong advocate of arbitration and mediation. The deliberations will further be illuminated by the presence of Justice Girish Kulkarni, Judge, Bombay High Court, Justice Sabyasachi Bhattacharya, Judge, Calcutta High Court, Justice C. Harishankar, Judge, Delhi High Court. From our own High Court, we are joined in the discussion by Justice A. Y. Kokje, Justice A. S. Supaiya, Justice Bhargav Dikaria, and Justice Sangeeta K. Vishen. Adding to the wealth of judicial insights are our guest panelists, Justice Ramesh Dhanuka, former Chief Justice, Bombay High Court, Justice Gautam Patel, former Judge, Bombay High Court, and Dr. S. Muralidhar, Senior Advocate, Supreme Court of India, former Chief Justice, Orissa High Court, whose judgments have left a lasting impact on arbitration jurisprudence. From the bar, we are fortunate to have eminent practitioners, Mr. Darius Khambata, former Advocate General of Maharashtra and Additional Solicitor General of India, who has immensely contributed in shaping jurisprudence on arbitration and commercial law at the highest levels. Mr. Gaurav Banerjee, Senior Advocate and former Additional Solicitor General of India, is highly regarded for his expertise and achievements in domestic and international arbitration. We will also be greatly enriched by the participation of distinguished senior advocates from the Supreme Court of India and other high courts as panelists. Mr. Balbir Singh, Senior Advocate, former Additional Solicitor General of India, Mr. N.L. Raja, Senior Advocate, Founding Director, Nani Palkiwala Center for Arbitration, Chennai, Mr. Nakul Devan, Senior Advocate and King's Counsel, leading international arbitration practitioner with practice spanning India, Singapore, and UK. Mr. Ritin Rai, Senior Advocate, eminent practitioner in arbitration and commercial disputes. Mr. Anirudh Krishnan, prominent practitioner before international arbitration institutions. Their expertise and perspective will ensure that the discussion in this conference are both deep in substance and broad in vision. Closer to home, we have Mr. Kamal Trivedi, the Advocate General of the State of Gujarat, who has played a pivotal role in guiding the state's approach to arbitration and legal policy, ensuring robust institutional support for ADR mechanism. I must acknowledge the valuable inputs given by Mr. Kamal Trivedi, in curating the topics and giving shape to this conference since its inception. Alongside, the panelists include senior advocate and legal stalwarts from our own bar, Mr. Mihir Thakur, Mr. Saurabh Suparkar, and Mr. Unmesh Shukla, who have immensely contributed to the practice of arbitration and commercial laws, carrying forward a tradition of excellence that strengthens dispute resolution at every level. We look forward to Mr. Tushar Mehta, Solicitor General of India, addressing us in the concluding session and sharing his perspective on the way forward. I extend my heartfelt gratitude both on my behalf and on behalf of my sister and brother judges to all our distinguished panelists, eminent judges, and senior advocates from across the country, whose participation in the panel discussion will enrich the conference with their wisdom and practical insights on arbitration. This collective effort will ensure that the benefit of speed, efficiency, and fairness, which the regime of arbitration law promises, are not confined to commercial hubs, but are made accessible to litigants across the state of Gujarat. Arbitration today is a cornerstone of modern justice. It is a system of justice delivery which is fair, efficient, and responsive to commercial needs. By avoiding procedural delays of traditional civil litigation, it ensures that the disputes are resolved quickly and effectively. Arbitration is not a new concept for us. Even in our ancient traditions, disputes within communities were often resolved by panchayats or neutral elders chosen by the parties themselves. The underlying principle was the same. The dispute should be resolved quickly, fairly, and without unnecessary hostility. In colonial India, arbitration was first regulated by the Arbitration Act 1899, followed by Comprehensive Arbitration Act 1940. A watershed movement came with the Arbitration and Conciliation Act 1996, based on the UNCITRAL model laws, which align Indian arbitration law with international standards, emphasizing party autonomy, minimal judicial intervention, and finality of awards. Over time, judicial interpretations have played a defining role in shaping the contours of the arbitration law in India. Our courts have consistently strived to balance two imperatives: upholding the contractual sanctity and finality of arbitral awards while balancing the need for judicial oversight, ensuring that justice and fairness remain paramount consideration for the arbitrators. The arc of arbitration jurisprudence and the journey from Renu Sagar to Sangyong tells a compelling story that India has steadily moved from an era of excessive judicial intervention to a modern arbitration-friendly regime that inspires confidence both at the domestic and international level. This evolutionary journey highlights a simple truth. Arbitration in India is not static, it is dynamic, growing, and adapting to new realities. In my experience while dealing with arbitration matters, my belief has become stronger that institutional arbitration, with its well structured procedure and adherence to schedules, is a more effective option as it builds credibility and makes arbitration cost effective. Gujarat High Court Arbitration Center has, since its inception in February 2021, achieved an impressive arbitration resolution rate of 55%. By September 30, 2024, the Arbitration Center has conducted 1,886 meetings in person, virtual, and hybrid mode. The Gujarat High Court Arbitration Center as an institution has been actively supporting and will continue to strengthen institutional arbitration. Our plans for establishing a new arbitration center with the state-of-art facilities within the precincts of the High Court of Gujarat are at the final stage. I am confident that this new facility will give further momentum to this initiative. Let me take this opportunity to emphasize that mediation and arbitration are not two competing models. They are complementary tools of justice. Both are vital pillars of modern dispute resolution. As Joseph Greenbaum aptly said, and I quote, "An ounce of mediation is worth a pound of arbitration and a ton of litigation." Unquote. This statement perfectly captures why we must strengthen both mediation and arbitration as complementary tools for modern dispute resolution. In keeping with this vision, the Gujarat High Court has launched India's first of its kind MedArb Center on August 15, 2024, under the aegis of the Gujarat High Court Arbitration Center. The fusion of mediation and arbitration at both pre and post referral stages offers unique flexibility and certainty to the parties at the same time. Our effort is to provide a forum to the parties where they can continue to have control over their dispute while finding a solution to their own problems and go back home with a win-win situation for all. The seed of this conference was sown during a session at the Conference on International Arbitration and the Rule of Law in Delhi, held to mark the celebration of 75th year of the establishment of the Supreme Court of India. On 14th September 2024, during the fourth working session on the topic of India's arbitration chronicle, Mr. Justice Girish S. Kulkarni, our esteemed panelists present with us today, highlighted the need to engage judges of the district judiciary as they decide matters under Section 34. As the Chief Justice of the High Court, I made a promise to organize an event specially for the Gujarat judiciary. It took us 1 year, 1 full year, to materialize the same, but I am delighted that the journey has now begun. This event represents not just the culmination of that promise, but also a step forward in fostering awareness and laying the foundation for a stronger, more informed approach to arbitration in the state of Gujarat. A special note of thanks to Mr. Justice B.D. Karya, Justice Sangeeta K. Vishen, Mr. Justice Chikati M. Roy, Mr. Justice Nikhil S. Roy, Justice H.D. Sudhar, the Board of Governors of the Gujarat State Judicial Academy, for giving shape to my discrete ideas of holding this conference with their efficient planning and coordination. I also extend my heartfelt appreciation to all my brother and sister judges of the High Court of Gujarat for their consistent support. It is their collective spirit and hard work that makes these achievements possible. Special thanks to Justice Pranav Trivedi for everything. Thanks to all the judicial officers of the Registry and Gujarat State Judicial Academy, support staff, and every member of the organizing committee, whose coordination and cooperation make this pioneering event a reality. I once again express my sincere gratitude to Honorable Mr. Justice N.V. Anjaria, Judge Supreme Court of India, for accepting our invitation to grace the event as a chief guest. A special word of thanks to all the panelists for graciously taking out time from their busy schedules by accepting our invitation. I must thank from the bottom of my heart to the young advocates of our High Court, Mr. Dhaval D. Vyas, Senior Advocate, Mr. Tarak Damani, Mr. Anush Trivedi, Mr. Shamik Bhatt, Mr. Jamin Dave, Mr. Kunal Vyas, Ms. Priyal Parikh, Mr. Shashwat Shukla, who have enthusiastically accepted our offer to assist the panelists and helped in shaping the contours of the discussion by providing material with their meticulous research work. Their enthusiastic participation as a backstage support strengthens my strong belief that our institution is in safe hands. Our deep note of appreciation goes to Ms. Gargi Vyas and Mr. J. Kansara, the masters of the ceremony. I must acknowledge that without the cooperation of all, it was an impossible task. As we embark on these 2 days of discussion and learning, let us remember that our collective efforts will enrich and strengthen the fabric of alternative dispute resolution, not only for the state of Gujarat, but for the entire country. May the spirit of learning and collaboration at this conference continue to guide the legal fraternity of the state in the years ahead. Thank you all for your presence, participation, and support. Jai Hind.
Thank you, my lord, the Chief Justice, for this warm welcome speech.
We shall now begin with felicitation. Honorable the Chief Justice of the Gujarat High Court is requested to felicitate Honorable Mr. Justice N.V. Anjaria, Judge of the Supreme Court. Please, my lords. Obliged lordships. May we now request Honorable Mr. Justice A. Vaikokje, the senior most judge of Gujarat High Court, to felicitate Honorable the Chief Justice of Gujarat High Court. I now request Honorable Director of the Gujarat State Judicial Academy, Shri Rohin K. Chudawala, to felicitate Honorable Mr. Justice A. Vaikokje, Judge, High Court of Gujarat. Thank you, sir. We now request Honorable Registrar General, High Court of Gujarat, Shri Sanjay Suthar, to felicitate Honorable Mr. Justice A.S. Supaiya, Judge, High Court of Gujarat. We'd now like to request Honorable Registrar Administration, High Court of Gujarat, Shri Nikhil Joshi, to felicitate Honorable Mr. Justice Bhargav D. Karia, Judge, High Court of Gujarat. Thank you, sir.
May we now request our chief guest, Honorable Mr. Justice N.V. Anjaria, Judge, Supreme Court of India, to give the inaugural speech to the gathering.
Normally, the clapping occurs at the end of the speech. You have done it in the beginning. So I don't know what I should understand. The Chief Justice, Surasri Sunita Agarwal, I would say my Chief Justice of my High Court, personal perception. Justice Alpesh Kokje, Senior Most Judge. Justice Arvind Supaiya, who is guilty of misrepresenting his height. Justice Bhargav Karya, taxing judge. He sat with me in a tax bench. So he was both taxing and teaching to me. It is very good to see all of them to have been ascended to the senior positions in the judgeship of this High Court. Down the dais, my sister and brother judges of this High Court, many of them have shared bench with me. And the memories run fast, come fast. Mr. Sri Hima Kohli, a respected personality amongst us, former judge of the Supreme Court, Justice Bhattacharya from Calcutta High Court, Justice Girish Kulkarni from Bombay High Court, Sri Daras Kambata, Sri Anirudh Krishnan, Gaurav Banerjee, Ritin Rai, Balbir Singh, all are eminent and prominent in their respective field. I know I'm missing somebody, so pardon me. All panelists, expert panelists present here. Experienced and erudite Advocate General of the state, Kamal Bhai Trivedi, ever live Manisha Ben, Mr. Virk, Public Prosecutor, Mr. Amin, is smiling, ever smiling. Right now also smiling. Then the panelist whom I know personally, had a benefit of having the arguments in the High Court. I think Mr. Mihir Thakur, I think he's not here, in absentia. Whenever he argued, you must convey to him. I used to make a point not to stop or curtail him, just to enjoy his academics and innovative argument submissions. Senior Advocate Mr. Saurabh Soparkar, from whom I continuously learn the lessons of sobriety, succinctness, and straightforwardness. Umesh Shukla, an artful senior advocate. Sanjay Suthar and Rohan Chudawala, both of my dear friends. Judicial officers who are here from across the state. Everybody present here. My homeland this is, so this campus, this building, these corridors and these courtrooms and these judges, my staff, very dear and near to me. At the outset, therefore, I thank and doubly thank the Chief Justice to invite me at this function and revive my memories. In the minute-to-minute program sent to me by Rohan Chudawala, 10 minutes are earmarked for the inaugural address. He is bona fide, thinking that this is the conference on arbitration. Arbitration should complete fast. Therefore, this function should also not be delayed. And I know the Chief Justice also is very strict. But then I thought that why should I abide by this time limit 10 minutes prescribed by Mr. Chudawala? When the arbitrators do not follow, arbitrators do not follow the mandate of Section 29A. So at the beginning, I file an application under subsection 4 of the 29A before the Chief Justice. Who is having roster, I know, about the arbitration, on the arbitration. So pardon me if I exceed the limit of that 1 year. Well, I'm not going to speak anything on the law of arbitration and judgments and niceties and principles and parameters. As such, I have brought a very long speech, like a book or like a award of the arbitrator, very long. All these aspects of law and this and that teachings we'll be discussing in the sessions of the conference, which are very meticulously and meaningfully carved out by the High Court and Academy. The idea of arbitration has roots in history. As back as in 1976, in Roscoe Pound Conference, Dr. Frank Sander, Dean of Harvard Law School, floated the concept of comprehensive justice center, which came to be known as multi-door courthouses. He wrote an article titled Fitting the Forum to the Fuss and explained as to which class of litigant which will suit or which type of ADR would suit which class of litigants. This multi-door courthouse can be imagined for India, where the courts are temples of justice, namely that this temple has many rooms, many spaces for different alternative dispute resolution systems. One for arbitration, one for conciliation, one for mediation, one for MEDAR, or Lok Adalat. So it is good that this High Court is a replica of such multi-house temple which entertains and conducts all types of ADRs in addition to the traditional justice delivery system. It was as back as in the times of Vedic times of Yagnavalkya. Arbitration bodies such as Sreni, Puga, and Kala were invented, known as panchayats. The Kula was a council of family members to resolve the domestic disputes. Sreni was an assembly of merchants and artisans from same trade or guild. A Puga was a village or town, assembly of people from various castes and professions to settle the disputes amongst the community members. It was like a system of panchayat, and this system of panchayat was recognized as back as in 1934 by the Privy Council in Vyatya Sitanna, that is 1980, AIR 1934 Privy Council 105. I quote a passage, and there is a purpose why I quote. Now in quotes, reference to a village panchayat is time-honored method of deciding disputes of this kind and has advantages that it is generally comparatively easy for the panchayatdars to ascertain the true facts, and that in this sense it avoids protracted litigation, which is observed by one of the witnesses might have proved ruinous to the estate. Looking at the evidence as a whole, the lordships see no reason for doubting that the award was a fair and honest settlement of a doubtful claim based on legal and moral grounds, and therefore of the opinion that there are no grounds for interfering with, the appeal must fail. Now, this passage highlights certain essential ingredients of the arbitration process. First, it must be an easy process, free from procedural wrangles. Secondly, it is a fair settlement of dispute, fair to both the sides. Thirdly, speedy and inexpensive. Fourthly, it is honest settlement. And fifthly, which is in my view more important, it says that it is the dispute will be settled both on legal and moral grounds. So moral intake in the arbitration process, in the entertainment of claims, and in making awards is a very essential component. That marks a departure from the traditional justice delivery system, where we deliver justice in accordance with law. Here, the justice could be provided the parties and arbitrator are honest based on the moral things or with moral intake. The statutory arbitration was introduced in India at the time when Lord Cornwallis was Governor General. The different acts, Madras Act and then the 1948 Act, 40 Act of the Arbitration Act were extended to the territories of India. I do not go in that. Bombay Regulation Act 1799, Arbitration Laws of 1899. They give the codification to the concept of arbitration. When we come to the system of arbitration, basically it is, I would say, a voluntarily chosen and self-evolved private mechanism to solve and put an end to the disputes. The unique feature of arbitration is that parties choose their own judges, who would be the arbitrators. Nobody would say that you are indulging in forum shopping. Ordinarily, since it is a self-chosen system, the litigants would, or parties to the arbitration would stand satisfied to a large extent by the process and the outcome of the process, except sometimes for the reason of the fees of the arbitrator. So there are advantages of this system, this mechanism. If I count, first it is voluntarily chosen. And when the judges or arbitrators are chosen by the parties themselves, there is no trust deficit. One of the most important reasons which can be attributed as a good feature of the arbitration is that this mechanism ensures presence of control of the parties over the proceedings, which is absent in the traditional methods of dispute resolution. Since the parties want to control how the proceedings would be conducted and choose the alternate system, they are the party-controlled delivery system. Less cumbersome procedure. The arbitration is a process where equity would follow law. Or I say law will follow equity, converse to the traditional system. The equity must have the predominant role in solving the dispute. The arbitration is junior lawyers den, because in arbitration you learn all the laws. It's a very, very peculiar and wonderful thing. When you conduct an arbitration, you have to understand the principles of Contract Act, Partnership Act, Transfer of Property Act, Civil Procedure Code. So a junior who attends the session of arbitration may come out with lot of benefits in learning. As a judicial officers, you have to deal with the arbitration cases where Section 5 of the 1996 Act, which is about the minimal judicial intervention in the process. This fundamental concept is the hallmark of the arbitration law and pervades the very concept of the arbitration. The 7 judges bench recently in that stamp duty matter stated that Section 5 is an internal aid to construe all the provisions of the Arbitration Act. Then Section 7, what is the arbitration agreement? Section 8, 9, power to refer the disputes to arbitration. Section 9, interim measures, where the jurisdiction is guided by the principles analogous to Order 39, Rule 1, Order 38, Rule 5. Section 34, setting aside of the award of the arbitrator, limited parameters. Section 36, enforcement and stay of the awards. Section 37, I'm just counting these sections which are very important to the judicial officers at the district level who will deal with the arbitration cases. In Guru Nanak Foundation versus Ratan Singh, 1984, 4 SCC, 634. It was in the context of the 1940 Act, Arbitration Act 1940. But I love to quote. This is by Justice D.A. Desai. I quote about arbitration. Interminable, time-consuming, complex, and expensive court procedures impelled the jurist to search an alternative forum, less formal, more effective, and speedy for resolution of disputes, avoiding procedural claptrap. And this led them to Arbitration Act 1940. However, the way in which the proceedings under the Act are conducted has made lawyers laugh and the legal philosophers weep. Experience shows that law reports bear ample testimony that the proceedings under the Act have become highly technical, accompanied by unending proximity, at every stage providing a legal trap to unwary. Informal forum chosen by the parties for expeditious disposal for the disputes has by decision of the courts has been clothed with legalacy of unforeseeable complexity. Unquote. Now this dictum perhaps continues to hold good also in respect of 1996 Act. Though in the amendments of 2015, 19, 21, the attempt is made by legislature to overcome these drawbacks, I have my own doubts. Somebody says that it is lawyer's paradise. I just added, it is not only a lawyer's paradise, but it's arbitrator's joyride also. I'm really not critical of the process, but just trying to highlight what needs to be done in the area. Certain dictums of law are or certain dictums of certain lessons are to be learned perennially. And this is the dictum which is true for 1948 Act, is also true for 1996 Act. It is because of this minus points of arbitration process. There is an ardent school of thoughts even today, which prefers to seek justice from the persons in the traditional attire, sitting and sweating in the courtroom, normal courtroom, rather than opting for or looking at the suited group of arbitrators and lawyers. The arbitration should not become, that is my firm belief, the rendezvous for elitist. It should be a common man friendly mechanism if it is to work as real alternative justice delivery system. I think this is the main challenge of the day when we deal with the arbitration laws. Let me count now certain areas which are critical, also emerging areas. First is group company doctrine. The Supreme Court in Cox and Kings 2024 4 SCC incorporated the concept of group companies doctrine, which allows even the non-signatories of the arbitral award of the agreement to be arrayed as parties in the arbitration. By doing so, the conventional jurisprudence of doctrine of privity, that only the parties which are signatory to contract are bound by it, is getting effaced. Secondly, lack of expertise of judicial officers dealing with complex arbitrations under Section 34 and 37, the result of which is huge pendency of cases in the courts, which is counterproductive to the very idea of arbitration, where party expects quick resolution of disputes. I must share a thing not to be quoted, that while sitting with a senior judge in the Supreme Court, we come across an SLP arising out of Section 37 proceedings, 25 years old. So this is the length of arbitration process. Then next is need to strengthen the institutional rules of arbitration. Then the judgment of Core versus ECI on unilateral appointment clauses. Judgment would be beneficial in public-private partnerships where the arbitration clauses are asymmetrical. But these asymmetrical clauses should not be preferred because it gives upper hand to one party. The other area, investment arbitration, one of the most popular methods whereby the investors can invest huge sums of money in a foreign country or in a foreign entity, is strengthen a bilateral investment treaty. The arbitration is established itself as one of the options in this area also. One of the forgotten section or overlooked section of Arbitration Act is Section 30, which deals with settlement. It says that it is not incompatible with an arbitration agreement for an arbitral tribunal to encourage the settlement of the dispute with agreement of parties, of course, by use of mediation, conciliation, and other procedures. So this idea of encouraging conciliation and mediation within the arbitration process should be encouraged. It might help in speedy outcomes of resolution. I attempted to search out goods and bads of the arbitration process without addressing anybody or anything specifically. I'm sure that this conference would chalk out the path for arbitration by dispelling the doubts and apprehensions which persist for the effectiveness of the arbitration and the utility of it as an alternative dispute resolution system. Fali Nariman, in his work on arbitration, uses a word phrase for arbitration: harmony amidst disharmony. So we must harmonize the arbitration, steering it clear from all chores of disharmony. I congratulate the High Court, the Chief Justice, the Academy for encouraging through the effectively run arbitration center here and also establishing the MEDAR Center in 2024 to give fillip to the alternative dispute resolution system to the aid of the litigants. And I have no doubt in my mind that the two-day conference organized today and tomorrow by the High Court with the Gujarat State Legal Academy on the arbitration laws will be instrumental in inventing and reinventing the purpose and spirit of arbitration. So with this, I take permission. Thank you, all of you.
Thank you for that enlightening speech and the candidness showed by my Lord Justice Anjaria.
May we now request Honorable Mr. Justice A.Y. Kokje, Judge, High Court of Gujarat, to offer vote of thanks.
Respected Justice N.V. Anjaria, Judge, Supreme Court of India. Respected Chief Justice Sunita Agarwal, Patron-in-Chief of Gujarat State Judicial Academy. Brother Justice Supaya and Brother Justice Bhargav Karya, Sister and Brother Judges of Gujarat High Court. Respected Ms. Justice Hima Kohli, former Judge, Supreme Court of India. Respected Justice Girish Kulkarni, Judge, Bombay High Court. Respected Justice Sabyasachi Bhattacharya, Judge, Calcutta High Court. Respected Kamal Trivedi, Learned Advocate General and his team. All the respected panelists present from all over India. A very good morning to all. It's indeed a great matter of great pleasure to propose a vote of thanks on the inaugural session of two-day arbitration conference. On behalf of the Gujarat High Court, I thank Justice N.V. Anjaria for accepting our invitation and gracing us with his esteemed presence. We are deeply indebted to your Lordship for your gracious words of wisdom, which inspires us all. I must thank our Chief Justice Sunita Agarwal for planning this conference. Your vision for strengthening alternative dispute resolution mechanisms and your steadfast commitment has been constant inspiration. The warmth with which you have welcomed our participants and participating in minutest details reflects your concern for nurturing the judiciary and bar alike. I also extend my sincere thanks to Brother Judges Justice S. Supaya and Justice Karya for their esteemed presence in the inaugural session, and their association with this conference adds immense value, and their continued encouragement strengthens the resolve of the Academy to organize such events. I also extend a sincere thanks to the member of Board of Governors of Gujarat State Judicial Academy for their esteemed presence in the inaugural session and for their efforts to make the event run smoothly. We are profoundly thankful to our esteemed chairs and panelists, Justice Hima Kohli, former Judge, Supreme Court of India, Justice Girish Kulkarni, Justice A.S. Supaiya, Justice Sabyasachi Bhattacharya, Justice C. Harishankar, Justice Sangeeta Vishen, Justice Bhargav Karya, Justice Ramesh Dhanuka, Justice Gautam Patel. Our sincere appreciation goes to the eminent members of the bar, Mr. Kamal Trivedi, Advocate General, Dr. S. Muralidhar, Mr. Mihir Thakur, Mr. Darayas Khambata, Mr. Gaurav Banerjee, Mr. Barbir Singh, Mr. Ritin Rai, Mr. Saurabh Soparkar, Mr. Nakul Devan, Mr. Anirudh Krishnan, Mr. N.L. Raja, Mr. Unmesh Shukla, who are also the panelists in different sessions and who will share their knowledge and experience on arbitration law. Our heartfelt appreciation for the organizing committee of Gujarat State Judicial Academy, led by the director, Mr. Rohan Chudawala, and his team of directors, Registrar General, Mr. S.D. Suthar, and his entire team for extending all the necessary support. A special word of appreciation for Mr. Jai Kansara and Ms. Gargi Vyas, advocates of Gujarat High Court, who have accepted to be the masters of the ceremony on this two-day conference. I wish them all the best for the coming 2 days. A special word of appreciation also goes to the assisting advocates, who have supported the smooth functioning of this conference. I may name them: Ms. Priyal Parikh, Mr. Shashwat Shukla, Mr. Dhaval Vyas, Mr. Kunal Vyas, Mr. Anuj Trivedi, Mr. Jaimin Dave, Mr. Tarak Damani, Mr. Shamik Bhatt. Their efforts behind the scene have been vital in ensuring the seamless and coordination of all sessions. A word of special gratitude is reserved for the participants, our learned members of the district judiciary, and the lawyers from various parts who have joined us in large number. Your enthusiastic response, your eagerness to learn, and your commitment to professional growth are what makes such conferences meaningful. We are confident that the exchange of ideas over the next 2 days will enrich not only your own practice, but also broader cause of the justice and reduce the pendency of civil litigation and encourage the adoption of ADR. Behind the scenes, numerous hands have worked silently yet tirelessly to ensure the smooth conduct of this event. We extend our warm thanks to the administrative staff of the Gujarat State Judicial Academy, the protocol and security personnel of the High Court of Gujarat, the IT team, and the support staff who have worked with dedication to make the session a success. On behalf of Gujarat High Court and State Judicial Academy, I once again thank one and all. Jai Hind.
Obliged, Your Lordships. And with that, we conclude our inaugural session. We would now like to request honorable dignitaries to gather for a group photo, Your Lordships. On the dais and off the dais, please. Ji, please.
And the distinguished panel members to be on the stage first. May we request Honorable the Chief Justice, Honorable Mrs. Sunita Agarwal, Honorable Mr. Justice A.Y. Kokje, Shri Kamalbhai Trivedi, Mr. Mihir Thakur, Mr. Darayas Khambata, and Mr. Gaurav Banerjee to be on stage, please. Electronic, sir. We would not be doing justice without doing a brief introduction of our distinguished panel members.
Ladies and gentlemen, we please request you to settle down so that the session can begin soon.
Everyone, please settle down so that we can start now, and please maybe request everybody to keep silence, please, so that the proceeding can be taken forward. It is our distinct honor today to introduce this panel before you, where the chair for today's first panel is our Honorable the Chief Justice Srimati Sunita Agarwal, who is the second woman to serve as Chief Justice in the distinguished history of our High Court. Honorable the Chief Justice has authored landmark judgments clarifying key provisions of the arbitration, including the interpretation of statutory limitation, the boundaries of party autonomy, and the doctrine of severability in arbitral awards. Her leadership, clarity in legal reasoning, and commitment to ensuring justice have made Honorable the Chief Justice a guiding force in promoting arbitration as an effective tool for dispute resolution. Today's conference, which is centered on arbitration, embodies her vision for fostering collaboration and settling differences through effective and constructive engagement. It is this spirit that sets the tone for our discussion today. With her profound expertise and a remarkable legacy of service, Honorable the Chief Justice brings unmatched insight to our deliberations that we are going to have today. It is with great pleasure that we invite her to chair today's panel and lead to what promises to be a meaningful discourse on arbitration.
The next panelist today is the senior most judge of our High Court, Honorable Mr. Justice A. Vaikokji, who has served with great dedication since his elevation in 2016. My Lord's deep understanding of arbitration law and court jurisprudence makes him an invaluable panelist for today's discussion. His insights will greatly enhance our exploration of the essence and philosophy of arbitration, the crucial role of courts in limiting judicial interference, and the nuanced applications of Section 34 and 37 regarding setting aside of the arbitral awards and the appellate review. Furthermore, his expertise will shed light on the modification and severance of arbitral awards, ensuring that our discourse remains comprehensive and grounded in practical judicial experience. Thank you, Allotus, for being a part of the conference.
Next on our panel, we have is none other than Shri Kamalbhai Trivedi, a distinguished senior advocate and the current Advocate General of the state of Gujarat, a position that Sir has held with great dedication since April 2006. Sir's legal journey is marked by his profound expertise in constitutional, commercial, and policy matters that have shaped Gujarat's development trajectory. He has been the legal voice behind landmark projects such as Sardar Sarovar Dam, GIFT City, the Bullet Train, and the Statue of Unity, to name a few. As the highest law officer of the state, Sir serves as a vital bridge between the executive and the judiciary. With such a vast experience, he is exceptionally well positioned to contribute his invaluable insights on the arbitration discourse, especially concerning judicial interference, public policy considerations under Section 34, and appellate roles under Section 37 of the Arbitration Act. We welcome you, sir, and thank you for your participation.
Our next panelist is a distinguished senior advocate of our own High Court, Shri Mihir Thakur, whose career at Gujarat High Court spans more than 4 decades. Though Sir once aspired to be a mathematics professor, he chose to take up law later, a choice that has enriched the profession immensely. He is widely regarded for his expertise in arbitration, having represented leading corporate houses and public sector entities in major arbitral proceedings and mentored lawyers in effective dispute resolution. On the crucial and integral aspect of party autonomy, Sir argued that nationality of the parties or the venue of arbitration does not affect the nature of the award. He advanced that Indian law permits 2 Indian parties to select a foreign seat and that enforcement should proceed under Part 2 of the Arbitration and Conciliation Act. The Gujarat High Court then held that 2 Indian parties could indeed opt for a foreign seat and that such an award constituted a foreign award for the purpose of enforcement. This position was later affirmed by the Honorable Supreme Court, setting a crucial precedent in the arbitration law. Thank you, sir, for your continuing support and guidance in this field.
Our next panelist is Senior Counsel Mr. Darius Khambata, who is one of country's foremost legal minds. Mr. Khambata holds an LLM degree from Harvard Law School and is a member of 1 Essex Court, London. Mr. Khambata joined the bar as a junior to none other than the legendary senior advocate, late Mr. Iqbal Chagla. Sir is a sought-after senior counsel not only before the Honorable Supreme Court of India, but before various high courts of our country. Sir has many accolades to his credit. We shall not be in a position to narrate all of these achievements, of course, considering the time constraints. But to name a few, in 2014, Sir was conferred with Arya Chanakya Puraskar for Law. Thereafter, in 2017, he received Senior Counsel of the Year by Legal Era. Last but not the least, Sir was also awarded Living Legend of Law by the Bar Association of India. Sir was called to bar in 1984 and was designated as a senior in 2005. Mr. Khambata has an expansive practice covering constitutional, commercial, securities and administrative law, as well as domestic and international arbitration. Mr. Khambata has held 2 distinguished public offices, one as an Additional Solicitor General of India and then Advocate General for the state of Maharashtra, where he earned the highest appreciation for his meritorious service. His deep expertise in arbitration is backed by significant roles, including Vice President of the London Court of International Arbitration and member on the Singapore International Arbitration Centre Court. Sir's extraordinary breadth covers the core philosophy of arbitration, respecting party autonomy, while acknowledging the delicate balance courts must maintain with minimal judicial interference. His experience affords profound insight into the interpretation of Section 34 and 37 of the Arbitration Act, especially concerning the defense of public policy and the appellate jurisdiction in arbitration matters. Moreover, his knowledge of modification and severance of arbitral awards enhances understanding of arbitration's practical and legal challenges. It is an absolute pleasure to have you, sir, for this deliberation today.
Our last panelist for the session is none other than Senior Advocate Mr. Gaurav Banerjee, who is an alumnus of the Magdalen College, Cambridge University, where he graduated with first-class honors in law and was called to the bar at the Lincoln's Inn in 1990. Designated as a senior advocate by the Honorable Supreme Court in December 2003, Sir has since appeared extensively before the Honorable Supreme Court and other high courts across the country. Sir, too, has been awarded Senior Counsel of the Year in the 11th Annual Legal Era Awards in the year 2022. Between 2019 and 2014, Sir served as the Additional Solicitor General for the Union of India, representing government in several landmark and constitutionally significant cases. His acumen in arbitration has also made him a sought-after amicus curiae in Supreme Court matters concerning arbitration agreements and enforcement of foreign awards. Sir's vast experience includes participation in and contribution to major arbitral reforms and policy discussions in the country. He is also an overseas associate at the Essex Court Chambers, London, further highlighting his international arbitration credentials. His rare combination of academic training, wide-ranging litigation experience, and authoritative command over arbitration makes him an unparalleled asset in legal forums and arbitration panels. Thank you, sir, for agreeing to be a part of this panel and for sharing your invaluable insights on the subject. May I now request the chairperson, Honorable the Chief Justice, to take the session forward from here.
A very good afternoon to all. When we speak of arbitration, we are really speaking of a process rooted in human relationship. Dispute often arise not only between strangers, but more frequently between those who have known each other for long like business partners, associates, companies, etc. Engaging in continuing dealing with each other, the essence of arbitration lies in resolving such disputes without harming the relationship. By placing their differences before a neutral third arbitrator of their own choice, the parties seek not only a fair decision, but also a process that preserves trust, respect their past association, and safeguards their future. The legislative intent to promote alternative dispute resolution is also evident in Section 89 of the Code of Civil Procedure by formally recognizing arbitration, conciliation, mediation, and settlement through lok adalats. We are reminded that the justice system must not only decide disputes but also preserve relationships wherever possible. The core philosophy of arbitration is party autonomy. When parties enter into an arbitration agreement, they are making a conscious and deliberate choice to step away from the traditional court system and entrust their disputes to a private tribunal. As Jan Paulson eloquently explains in his seminal work, The Idea of Arbitration, the legitimacy of arbitration flows from this genuine consent, and it is this consent that the courts at institutional level must respect and maintain while dealing with matters arising out of Arbitration and Conciliation Act 1996. It must be remembered that when courts act as judicial authorities under the 1996 Act, they are not exercising their original and inherent powers as courts of law, but as statutory authorities whose powers are circumscribed by the 1996 Act. The district judiciary is an integral part of our national legal system that has a major role to play in India's ambition to be a for international arbitration. Chief Justice Sundaresh Menon of Singapore, in his 2018 address at the Nani Palkiwala Arbitration Center in Delhi, identified finality as one of the arbitration's most attractive features so far as attracting foreign and institutional arbitration is concerned. Unlike court proceedings, where multiple levels of appeal can extend disputes for decades, arbitration offers closure. The award is final, subject only to limited grounds of challenge. This finality is not to be seen as a flaw or something to be rectified, but rather it is a feature that parties specifically bargain for. Beyond finality, arbitration offers a measure of confidentiality and flexibility. The proceedings takes place away from the public eye, and parties can choose procedures suited to their specific dispute rather than being bound by rigid rules of civil procedure and evidence. It offers the benefits of expertise. For example, complex technical disputes can be decided by engineers, construction experts, or industry specialists rather than judges who are generalists in their field. And lastly, arbitration promises speed and efficiency. However, all these vital features of arbitration are only as good as the national legal system will allow them to be. The promise of arbitration can realize its full potential only when courts resist the temptation to intervene unnecessarily and respect the autonomy of the parties and independence of the arbitral process. The cornerstone of the role of courts in arbitration is a short tenet of faith, minimal judicial intervention. Section 5 of the 1996 Act embodies this very principle. It states, notwithstanding anything contained in any other law, no judicial authority shall intervene, except where so provided in this part. This is not merely a procedural provision. It represents a fundamental shift in judicial philosophy, especially when compared with the Arbitration Act 1940. The Singapore Court of Appeal captured this philosophy perfectly in AKN versus ALC when it declared a critical foundational principle in arbitration is that the parties choose their adjudicators. Central to this is the notion of party autonomy. Just as the parties enjoy many of the benefits of party autonomy, so too must they accept the consequence of the choices they have made. The courts do not and must not interfere in the merits of an arbitral award, and in the process, bail out parties who have made choices that they might come to regret, or offer them a second chance to canvass the merits of their respective cases. This important prescription is reflected in the policy of minimal curial intervention in arbitration proceedings, a mainstay of the model law and the IIA. This principle calls for judicial restraint and is perhaps the hardest for courts to practice. As judges, we are trained to do justice and to correct errors, but in arbitration, it is required of courts to take a step back and resist the natural judicial instinct to improve upon the arbitrator's reasoning or to substitute when what the court believes is a better outcome. Lord Mains, former Deputy President of the Supreme Court of the United Kingdom, in his 30th annual Freshfields lecture observed that parties who choose arbitration have intentionally submitted themselves to the law of the seat and whatever controls it exerts. When parties, especially sophisticated commercial entities, choose arbitration, they do so with open eyes. They prefer the risk of an incorrect arbitral award to the certainty of prolonged litigation. Courts must honor this choice. This respect extends to accepting outcomes we might not have reached. Parties choose to repose their faith in private arbitration. They did not choose us. When we overturn awards too readily, we substitute our judgment for the party's choice, undermining the very autonomy that arbitration represents. The guiding principle is that the court is there to support, not to substitute, to protect, not to dominate. With these words, I throw open the discussion and request Mr. Kamal Trivedi to make his opening remark on the role of courts, object of minimal judicial intervention.
Justice.
Hello, check.
Thank you, Honorable the Chief Justice. And very good afternoon to everyone over here. When we speak on arbitration today, one principle stands out, which is absolutely fundamental, and that is doctrine of minimal judicial intervention during the course of arbitral proceedings. In my view, this doctrine is a lifeline of arbitration. Arbitration is nothing but a mechanism in alternative dispute resolution system. As was referred to by the Honorable the Chief Justice, prior to the enactment of today's Act of 1996, we had an old regime of Arbitration Act of 1940. Lot of shortcomings, lot of loopholes, and the mechanism was not functioning satisfactorily. There were three main reasons. Number one, excessive judicial interference by the courts. Perhaps during that time, courts were interfering on mere askance. And at any stage, right from the stage of the appointment of the arbitrators to the conduct of the proceedings of arbitration, to the rendition of award and challenge, and so on and so forth. The second reason, delay. Because of frequent interference, the arbitration proceedings used to take years together. They were going like as slow and as cumbersome like a civil litigation. And thirdly, absence of party autonomy. Instead of respecting party's choice to get the disputes resolved privately, the courts were having a dominating role, a supervisory hold practically on all stages of arbitration. And the Honorable Supreme Court used to criticize this act is a step in litigation rather than an alternative to it. Because of this, there was a loss of faith in this institution, in this mechanism. And that paved the way of the enactment of the Arbitration and Conciliation Act 1996. If you see the statement of objects and reasons, there are so many objectives set out. But three objectives are very important for our present purpose. Firstly, to minimize the supervisory role of the courts in arbitral proceedings. Secondly, to make the arbitration efficient, autonomous, and final. And thirdly, is very important, to bring India in line with global best practices. And for this purpose, the key section, as was referred to by the Honorable the Chief Justice, is Section 5, which starts with the non-obstant clause. It says that notwithstanding anything contained in any law, no judicial authority shall intervene in any matters covered by Part 1, except provided in Part 1 itself. So this controls the whole philosophy of the Act. And we have provisions with reference to the arbitration proceedings, where court is to act as a facilitator, not as a dominator, not as a controller, like we have was referred to by our Honorable Justice Anjaria in the session, inaugural session, right from Section 8, when court is to see that parties are referred to arbitration if the contract contains the clause of arbitration. Section 9 is enabling the court to grant interim relief prior to the commencement of arbitration proceedings, during the course thereof, and afterwards. And now we are likely to have newly amended Section 9 that has been proposed in 2024 amendment, which would like to see that court's role is totally eliminated so far as during the course of arbitral proceedings is concerned, with addition of new Section 9A for the emergency arbitrator. Then we have section 11. When the parties don't agree for the appointment of an arbitrator, the court can refer the parties to the selected arbitrator. We have section 14, where the court can terminate the mandate of the arbitrator under certain circumstances. We have section 27, which court assists in recording of the evidence. And finally, 29A, which enables the court to extend the time limit for rendition of the award. So all these provisions suggest that court is to play a role of a facilitator. Thereafter, we come across three sections. Section 34, after the award is rendered, if it is challenged, of course, in a later part of this session, we are going to discuss as to what are the grounds under section 34 upon which the award can be challenged and can be set aside. Their court is to play a role which is a bit more than a facilitator and more on the judicial side. We have section 36 for the enforcement of the award and section 37 where court is exercising the appellate powers. So these are the provisions which show the court's intervention is permissible, but not as a dominating role. Along therewith, many times we come across the arbitral tribunal's orders where the question may arise, can they be challenged or not? The Apex Court has recently in a Cerosoft Solutions Private Limited's case catalogued three circumstances with a caveat that these are the circumstances of exceptional character. They are to be taken into consideration in a matter of rarity, where a writ jurisdiction invoking extraordinary jurisdiction of the High Court can be invoked by filing a writ petition in Article 226, 227 of the Constitution. The first is the order of the arbitral tribunal must be completely perverse. Of course, there is going to be a debate. What does perversity mean by? But the ordinary meaning is the order which defies, outrageously defies logic is a perverse order. An order which no reasonable man would ever make it is a perverse order. So if there is a complete perversity in the arbitral tribunal's order, that can perhaps be challenged in the High Court. The second eventuality is the order suffers from the vice of bad faith exercised by one of the parties. Once again, the area is debatable. We'll come to that. And thirdly, when the order leaves one of the parties remediless. So these are the circumstances of exceptional character where the arbitral tribunal's order can be challenged. So in a conclusion, I would say that, number one, we must take note of the fact that minimal judicial intervention is not just a statutory command, it is a matter of philosophy of the very arbitration. Number two, as I referred to, courts, namely the district judiciary, is to play a role of a facilitator when all these provisions come into picture, right from section 8, 9, 11, 14, 27 and 29A. And when it comes under section 34, we have statutorily circumscribed grounds which are of limited operation. On that, one can think of setting aside of the award. And now we have a new judgment where the court can remit the award back under certain circumstances. We are going to discuss on that. And lastly, as has been said, section 5 is a guiding factor. I don't say that minimal judicial intervention means no intervention. Intervention can be there. But in a case which demands that, if these things follow, in my humble view, of course, we are heading towards that pro-arbitration jurisdiction, but we can achieve that status as early as possible. Thank you.
So there is a question for you, Mr. Tamal Trivedi. To what extent have the courts managed to achieve the balance between party autonomy and independence of the arbitral process, on the one hand, and the perceived need for judicial intervention on the other?
I think it's a slightly a tricky question. If I were to make a political statement, I would say that today Indian courts are more closer than ever to strike this balance. We have got two very positive developments. First, party autonomy is generally respected by our courts. And our courts are not frequently interfering with the arbitral awards. And number two, Section 34 court means all of you know your responsibility when to interfere and when not to interfere. We have judgment like Perkins, Eastman, Architects, where the Honorable Supreme Court struck down the appointment of one of the arbitrators on the ground that he was the managing director of a company and he was likely to have an interest in the outcome of the dispute. So courts are not abdicating their role. As the time comes, they come in picture. So we are, it's a long journey. Trajectory is very clear. So while respecting party autonomy, if we use minimal judicial intervention doctrine as a safety valve, nothing better than that. Thank you.
Thank you, Mr. Trivedi, for enlightening us on the role of court and the object of concept of the whole arbitration law, which aligns the object of minimal judicial intervention. I would invite Mr. Mihir Thakur now to introduce on Section 34, understanding the rationale behind defending public policy and the limited scope of patent illegality.
Section 34 is an exception to Section 5 in one way, that this is the place where court can intervene and set aside an award. This is one scope where court's role comes in under the statute to set aside an award. Under what circumstances, I'll just talk about it. But it must be appreciated that court is not sitting as an appellate court, seeing a judgment of the trial court. It is sitting only to consider the arbitral award on certain grounds available. Section 34 has undergone an amendment in 2015, and the law has been substantially amended so as to qualitatively define public policy of India, as decided in Renu Sagar's case rather than in Sawpipe's case, while retaining the patent illegality in respect of Indian arbitral awards. The judgment of Session's case, the Supreme Court has decided that the amended provisions will apply to all Section 34 applications filed after 23/10/2015. 23/10/2015. So as a district court who is to decide Section 34, you will have to see whether that decision which is to be decided under the old act or under the amended provisions. Whether Section 34 is filed before 23/10/2015 or post 23/10/2015. The major distinction which is drawn between the two provisions is, one, if it's international arbitration will not come to the district court, but if it's a domestic arbitration and it comes to the district court, public policy of India is confined to as law as laid down in Renu Sagar's judgment and not as per Sawpipe's. However, patent illegality still remains a ground for setting aside the award. When you are deciding, it is not a situation where every award has to be upheld. The court has to look into it and decide whether there is a patent illegality, whether there is a public policy is breached. One thing is very clear, that there is a judgment of the Supreme Court which has been given a go by in light of the amendment, and that is Western Western Gecko International Limited, that has been brushed aside in view of the amendment, not saw pipes completely. But even saw pipes is narrowed down by using the word on the face of it, patent illegality on the face of it. So when you are deciding a matter, it is not, an approach should not be that since it's a matter arising from arbitration, we will reject all applications under 34. That is not a correct approach. It has to be looked at whether it's opposed to public policy, whether there is a patent illegality or not, and decide upon the basis. It's a pre-2310-2015 or post-2310-2015. I believe that there may be some matters which are pending even pre-2015. Therefore, those issues should be determined and decided. That's all. I leave it open to.
So, what brief introduction is given by Mr. Mihir Thakur with his expertise on practicing on the arbitration jurisdiction. My question to Mr. Darius Khambata is, have the 2015 amendments managed to rein the unruly horse of public policy and brought in clarity with regard to its scope? Before Mr. Khambata speak, after this, his address, we'll invite questions from the audience. So be ready with your questions on the public policy and the panelists also, they will be joining, because this is public policy is one thing, like which leads to lot of queries, even in my mind also.
Thank you, Chief Justice. I want to start by saying how impressed I am that the Gujarat High Court is holding this conference.
Thank you.
Because I think it has to be recognized that the highest national public policy is to make arbitration work in our country.
Correct.
There's no higher public policy than that. And we're all participants in that. We're all stakeholders. How is it to be done? We have to encourage an environment of fair, honest, and speedy dispute resolution. And it's only when one of these three criteria is violated that I really believe a Section 34 court should interfere. As my old friend Mirbhai has said, it's not an appellate jurisdiction. So the mindset has to be completely different. Now, in 2014, 2015, Law Commission had set up a committee. I was part of that committee. Justice A.P. Shah was the chair of the committee. And as Justice Anjaria told us, the experience under the 96 Act was often as bad as under the 1940 Act. And legal philosophers were weeping and we lawyers were laughing. Sometimes laughing all the way to the bank. That was not the basis for the 96 Act. That was not the objective of the 96 Act. Now, there are four important things that the 2015 amendments did. And I have to say it honestly, because though the committee was formed under the previous government, it then meandered a bit and the recommendations didn't really get much sway. When the new government came in, and I remember this personally, we got a call saying, no, we want to introduce this straight away in a matter of weeks, if not months. And it moved very fast after that. And that's why you have the 2015-26 amendments which came into force. I was personal witness to that. Now, four important changes got made to 34, and they should give us all a clue as to what Parliament and the government wanted. The first was that a distinction was made under 34 as to setting aside an award on the grounds of patent illegality and on the grounds it was contrary to public policy. It's a very important distinction because Renu Sagar's case had made that distinction in 1994 with the Foreign Awards Act. Because as you know, under the New York Convention, several countries of the world got together and India was amongst the first to ratify that if a foreign award is passed in a reciprocating jurisdiction, our courts, when it comes for enforcement, will not take a second look at the award. As long as it's not contrary to our public policy, we will enforce it. Never mind that the award might make a mistake. Never mind that we would have taken a different view on the evidence. Never mind that there may be a slight error of law also. Never mind that. We will enforce. Now, the 2015 amendment said that will be the regime for all international commercial arbitration seated in India. This is a huge jump forward because international commercial arbitrations, as you know, are arbitrations where one of the parties is foreign. So the idea was to attract investment and therefore attract arbitration and make India an arbitration house. A separate ground has been given of patent illegality, which applies only to purely domestic arbitration. So the very fact that these two are divided or dichotomized should tell us that they don't mean the same thing. And to introduce patent illegality under the ground of public policy will defeat the whole legislative purpose. So that's the first change. The second change is that the ground of public policy, which alone is the ground on which an international commercial arbitration award can be challenged, is the same when it comes to considering an award rendered seated in India, or it comes to enforcing a foreign award, which means the narrowest scrutiny. And the Supreme Court in HRD Sangyong has recognized this expressly, and that was the intent. So, international commercial arbitration in India was put on a different track from domestic arbitration. Thirdly, 34 also makes it clear that now public policy is restricted to only two very narrow grounds. And an award will be set aside, and the statute uses the words only if it is contrary to fundamental policy of Indian law, and two, to the most basic notions of justice and morality. So, every illegality, even if it is patent on the face of the award, is not a breach of public policy. If that were so, then the statute would have to be rewritten. So, it only some fundamental law, which is part of the common weal, part of our core public policy, if that is violated, obviously the award has to be set aside. Look, for example, if an award grants an award between two persons who are planning a theft or a robbery, or to share the proceeds of some embezzlement, that may be contrary to public policy. But short of that, short of something being contrary to our fundamental public policy, even if there is an illegality on the face of the award, it is not to be set aside on that ground. And the second ground of public policy is most basic notions of justice and morality. We heard Justice Anjaria this morning say that arbitration has a special component of equity. And in fact, the Arbitration Act has a provision that you can even appoint an arbitrator as what they call an amiable compositor, which is an amiable person who composes or composits a dispute. Or he can act ex aequo bono, which effectively just means he can apply equity, not the law. If you do that, then really the award is ring fence. And you may want to do that when you appoint an arbitrator in, say, a family dispute, where more than mere legal considerations might have to apply. But even otherwise, even a standard arbitrator can take into account elements of equity, as Justice Anjaria pointed out. Now, it doesn't mean that if a 34 court has a different view of what the equity should be, or a different view of what justice should have been, that it can set aside the award. And therefore, the 2015 amendment said, the award must violate your most basic notions of justice and morality. And for that, my simple hint to any 34 court is, please have a thick skin. Don't get sensitive about everything you see in an award, because it must be the most basic norm of justice or morality, not just a different view of justice or morality. So that's the third major change. The last change, and we sometimes overlook this, came even qua domestic awards. I told you that the separate ground had been added for patent illegality. Now that ground is caveated and qualified by an explanation to 34(2)(a). The explanation tells us that patent illegality, of course, must appear on the face of the award. It must be there. The old Privy Council in Chapsi Bara had said there must be a legal proposition on the face of the award which is wrong in law. But that exercise should not involve a reappreciation of evidence or even a correction of a wrong application of the law. These are the very words used in the statute. So these are very, very strict guardrails that have to be applied even qua patent illegality. And I think it's important because I am a firm believer that we can never become a truly international arbitration hub unless our domestic arbitration also goes up to that standard. You can't have one system going at a faster pace and the other pace. It has to be both.
Any doubt about that.
So therefore, we have to give the same sanctity to domestic awards and follow the statute. The statute already has very clear express guidelines. And we must not try and find a way through those guidelines by saying, I don't agree with this. Actually, this letter is more important than that piece of evidence. This should have been followed. That should have been done. And after coming to a conclusion which an appellate court would come to put in the mantra that therefore this is contrary to public policy or there's a patent illegality. Rather, I think the approach should be the other way around. One must start by asking the petitioner, like sometimes one does in a Section 100 second appeal under CPC. What is the exact challenge of patent illegality? Which part of this award can you point out? Which is the law which has been wrongly stated? And can we set aside this award without going into the facts, reappreciating in the evidence? And is it so patent? Is it merely a wrong application of the law? Or is the fundamental principle of the law being wrongly stated? That should be the opening inquiry. And then, of course, go into whatever is necessary to bolster that. So these 4 ways, a great change was made. Now, of course, as Meerbhai said, 34 is the exception to Section 5, but therefore it must be a very guarded exception. It cannot open the floodgates, because by opening the floodgates, we do not subserve that greater national public policy. Years ago, Lord Denning, you must have heard of Lord Denning, a famous Court of Appeal and then House of Lords judge, finally. He took that famous quote of Justice Burroughs, that public policy is an unruly horse. And by the way, the next sentence after that says, it is only argued when all other arguments fail.
Correct.
We never quote the
Correct.
second sentence. But what Lord Denning said is that with a firm rider in the saddle, that unruly horse can be tamed. Now that firm rider in the saddle is the judiciary. It is entirely up to the judiciary not to treat a 34 as a first appeal, nor even to treat it as an Article 226, because that it certainly is not. The guidelines are there in the Act. And that's why I say, above all, arbitrators, lawyers, but above all, our judiciary is the future of arbitration. It is up to you to make it work. And if you make it work, it can lead to a fantastic result. But you have to resist the temptation to interfere. Thank you.
Thank you, Mr. Khambata. Mr. Gaurav Banerjee wanted to add something to it.
Just wanted to add a few words, maybe put a slightly different spin on this. You've heard, first of all, I think this is a unique occasion where the judiciary is being addressed by
Lawyers.
So I think it is very important that there be this dialogue between the bar and the bench, particularly the district judiciary, because you will be faced with all of us appearing before you after giving you these long bhashans about non-interference, etc., etc. So I just wanted to just comment on some things that have been said. The learned AG talked about minimal judicial interference. The provision has been mentioned. It doesn't use the word minimal. It says except as otherwise provided under this Act.
Correct.
So one aspect I would like to highlight is this, that there are 2 main distinctions in our now amended Act. One is that we treat international commercial arbitration differently. 1996 model was the model law for international commercial arbitration. We tried to fit a square peg into a round hole. That problem has now been solved by a 2015 amendment. So for us lawyers, normally before the district judiciary, I would expect that it would be a domestic award that would be the subject matter of challenge. The subject matter of challenge in a domestic award necessarily is slightly wider than what it is in an ICA. That much is accepted. Where does one draw the line is a question, tricky question asked to the Honorable AG, and I think I will try and Mihir Bhai will also have something to say about it. But the second distinction I think the judiciary, the court should take into account is that pre-34 is really the domain of the arbitrator. Whether it is appointment of an arbitrator, whether it is a Section 9 situation, which normally should go to an arbitrator, maybe there is some role of the judiciary in intervening when there is a bias issue, but otherwise the philosophy is the second look is of the court, the first look is of the arbitrator. Even jurisdiction is with the arbitrator. Normally jurisdiction even under the old theory was circumscribed, but even that. So till the 34, normally the court should facilitate the process, or usually the court should facilitate the process. But in the 34 stage, the line that has to be drawn, I think there are some variations in thinking here, particularly when one comes as a lawyer, you know, we say all these things in conferences, then we come to you and say, now please set aside the award. That's the reality of the situation. What does the judge do? 34 is actually quite comprehensive. Everybody starts straight away going to patent illegality. There are a number of grounds in 34 which are there, which are to be made out, which are legitimate grounds, which I believe judges should look at and see whether any ground really fits into any of those heads. So far as patent illegality is concerned, I think Mihir Bhai has something more to say about it. But I'll just tell you one interesting anecdote, and Darius will laugh on this. This issue of patent illegality, this phrase is a judicially coined phrase, and it happened in ONGC and SAW pipes. And Justice M.B. Shah framed the phrase, and I can tell you exactly how it happened. I was assisting Mr. Ashok Desai, who was then the Attorney General, and we had suggested to it because under the 96 Act, public policy is very narrow because it's international commercial arbitration. So the Act really did not fit our domestic scenario. So we had suggested the phrase manifest disregard, which is an American phrase. But Ashok Bhai on the spot came out with this phrase of patent illegality, and that is how it found its way into
Mr. Banerjee, since you are referring to SAW pipes case, if I rightly recall, patent illegality by Justice Shah was related to public policy.
Correct. He tried to fit it in within
Public policy.
but the thinking was that because public policies were so narrow and the domestic situation was different from international commercial arbitration, so this new fourth heading was coined, and obviously that created a lot of pushback. And then the 2015 amendment came, which narrowed it and clarified it, where Mr. Khambata was a party. But what I'm saying is that when you find somebody with a 34 petition before you, there is a ground of patent illegality. It is narrow, but at the same time, you have to deal with it. And if it is a bad award, it should go. It is in the interest of arbitration that if it is a bad award, it should be set aside. It is not that it is 100% completely hands off and there is no scope for interference. There is always some supervisory role of the judiciary which is left. After all, arbitration is a means to an end. It is not some mantra that, you have to be pro-arbitration. There is a statute, there is a definition, you have to engage with it and you have to deal with it. You can't simply say 34, no interference. That was my own.
Mr. Banerjee, only one question. Exactly what do we mean by patent illegality in a simple words? Can illegality simplicity be a patent illegality, or it should be of a very trivial nature?
I think Mr. Thakur will answer that.
So before I would interrupt for a while, before we move on to patent illegality questions specifically, which I'm going to put to Mr. Thakur, I'm sure officers sitting there, they must have faced with the argument of Mr. Mihir Thakur in one or other arbitration matters. So I'm sure that you have that question in your mind. Whenever he argues about public policy, the violation conflict, award being in conflict with the public policy, then you must be facing with some kind of difficulty in dealing with his arguments.
Of course.
I'm sure that you must have faced that difficulty. So today, Mr. Mihir Thakur is on the other side. Now he has to answer your question.
So he used to come out with his clear
Not
picture.
as a law, he will not be able to argue as a lawyer today. So this is a golden opportunity for you. Please ask question as to how you will deal with the problem, with the arguments of a lawyer on the ground of challenging the award on the ground of conflict with the public policy. Please, any one of you, please come forward. Please ask, otherwise I will have to ask. Yes.
Happy to acknowledge he was my professor and he used to ask many inconvenient questions. Now is my time to make it even. Do you think that this too narrow a window of section 34 is really counterproductive to the arbitration process? Are we paying too much respect to party autonomy? We have experienced, sir, that governments and corporations are completely omitting arbitration clauses, being completely disillusioned by the awards. Is it not better that we open the window a little more and probably it will serve the arbitration better? Thank you.
I believe that there is a distinction which is drawn in the act between international commercial arbitration and domestic arbitration. In respect of domestic arbitration, the narrowing down of patent illegality was not required in my view, because I don't believe all arbitral awards are clean. In that light of the matter, there has to be a judicial intervention in respect of arbitral awards, at least the domestic arbitral awards. It may not be for international arbitral awards.
Can I just add, I can see Darius is not at all happy about it, but
No, before you add, one thing, the fact that we want to merge with the international arbitration scene is no reason why we should not interfere. There has to be interference.
I will go one step further. Most countries have a separate regime for international arbitration. So, for instance, Singapore has the IAA for international commercial arbitration. Their domestic act is different. There is nothing wrong if we want, it's a matter of public policy, generally, as to how wide we want to open the window. For instance, internationally, the thought process is maybe we should have some sort of appeal, which is very wide. Some other countries like the UK, England have a reference on a question of law. So, everybody says patent illegality invented in ONGC was very bad, but it was something that was required to open the domestic window slightly more. Today we have patent illegality. Our courts are still grappling with where we are going. If it is to be opened wider, I don't think there's an international problem with it.
Can I answer my learned friends? As I said, we should not have this viewpoint that domestic arbitration can proceed in one way, international arbitration in India should proceed another way. Ultimately, the two streams will merge if we want to become a leading arbitration center. It is also a question of mindset. If you see the acts, for example, in the UK, Mr. Banerjee will bear this out. The provision under which the courts can interfere with awards are far wider because the UK did not adopt the UNCITRAL model, at least the 96 Act. They're very wide provisions. And yet, if you see the statistics, barely 4 or 5 awards must have been interfered with in the last 20 years. So also other jurisdictions like Singapore, etc. Now, I'm not saying one size fits all. We have a unique system. We have to fashion a system which works within our form of arbitration. We didn't have the luxury of a separate act. Learned friends are right. We had to do what we could under this act. And what we did was effectively create a separate regime by having this distinction in standards within 34. So treat the International Commercial Arbitration Standard as a separate act, if you will. It doesn't make it any stronger or weaker. It's clearly a separate provision. Now, coming to patent illegality, the question, I agree with what has come from the audience. Sometimes one does see an award which is just bad. One can't put one's finger on it. Why? One cannot. Proving fraud or corruption is a very difficult thing. So what does a court do? Now, there will be such cases. I concede that completely. The decision before the government then and before Parliament was that for those cases which touchwood are still few and far between, you open up the window so wide as to effectively make arbitration only one step in the civil procedure hierarchy and then just go straight into an appeal. So the decision at the moment is patent illegality on the face of the award. Why are 2 terms used to signify it must be on the face of the award? Because patent also means something obvious. And it says patent illegality on the face of the award. And I think the anxiety is to say that first of all, the error of law must be there apparent.
Face of it.
It should not be something where you have to go into an involved process of reasoning. Because remember, the arbitrator is only meant to follow what the law is. A court can't get a brainwave post-award and say, oh, actually, I think the law should be this. Because then that's not fair to the arbitration. So it has to be patent. Law has to have been decided one way, or the statute must say one thing, the arbitrator says another. That's patent illegality on the face of the award. And that doesn't need anyone to go into reappreciation of evidence. Therefore, again, that clarification is very clear. The one clarification which may lead to gray area is the proviso says even an erroneous application of the law is not good enough.
Correct.
There is some gray area. I accept that, and it's easy for us lawyers to come and argue one way or the other. The problem always moves to the other side of the bar when it comes to the bench. So what is an erroneous application of law versus a patent illegality might cause some issues. But up to now, in my experience since 2015, I have not seen a single judgment that grapples with this. I've not seen a judgment which says that this is an erroneous application of law, but it's not a patent illegality. So usually in the main, judges have adopted a robust attitude that if there's a wrong proposition of law, or say the wrong article of the Limitation Act is followed, that's a patent illegality. The guardrail is don't try and redecide the matter on facts. I think it's reasonably clear, and I don't think there's any confusion on that.
So,
Justice Bhattacharya.
yes, please.
Mr. Khambata, do you think that this imposition of this error, patent illegality, akin to Order 47 standard review, error apparent on the face of record, this brings the review court, not the appellate court, the court to the same, in the shoes of the arbitrator himself, in a sense, that a court can review its own judgment if there's an error apparent on the face of record, which is distinguished from appeal, a higher notch. So aren't we putting the court on the same footing as the arbitrator? Shouldn't the court think in the shoes of the arbitrator, get in the skin of the arbitrator to see whether this I couldn't have passed, error apparent on the face of record, because the language is similar?
In fact, that's an excellent question, because when I mentioned that it should not involve a tortuous form of reasoning and investigation, I was thinking of the cases, even of the Supreme Court, on error apparent on the face of the record, which have stated this. I think your Lordship is absolutely correct. But with one qualification, that's a process only pertaining to the legal aspect. It doesn't allow the court to step into the shoes of the arbitrator factually. But legally, yes, he would have to decide what the law is. And again, there, as I said, this is a gray area. See, there is uncharted territory. Sometimes you have cases where the law has actually not been clearly decided. That becomes difficult because if the arbitrator takes a view based on his bona fide interpretation of what he or she thinks is the law, a 34 court really cannot reanalyze that and come to a different view of the law unless it's something so patent and so terribly wrong that a court has to interfere. So really, as I said, the discretion lies with the court. And that is why I said it's so important for the future of arbitration that that discretion is wisely and judiciously exercised.
I just go back to this expression patent illegality. Perhaps in my view, it's very wider concept. I pose a question. Supposing the award is rendered against the weight of the evidence, or if the award is based on no evidence, cannot one call it a patent illegal order?
Yes, it is.
Yes.
It is.
I was about to ask that question.
Can I answer?
If without analysis, without any analysis of facts.
It is.
I was referring to Delhi Airport Metro's case, where the apex court laid down as to what are the instances of patent illegality. Number one, when the award is in contravention of the act itself. When the award is in contravention of the substantive law, or the arbitrators have tried to wander around the reference or perversity. And supposing the award interprets a particular clause in a contract, which perhaps no reasonable man would interpret like that. So these are the instances of patent. So one can't say that only illegality is to be found out in terms of
As held in Matli Boy's case.
Yes.
Where it is held that there is no reason justifying the award.
Sorry,
It was
may I just clarify? I didn't mean illegality in the sense of an error of law. I mean any illegality which under established law amounts to an illegality, which would mean coming to a finding without there being no evidence at all to support it, which is a recognized ground of perversity. The gray area comes in the widening of perversity into vital evidence is not taken into account. Now that will require the court
Yes.
to exercise its judgment on what is vital and what is not. Therefore, I don't totally agree with that extension. But no evidence, of course.
So discretion is there. Discretion has to be exercised carefully, circumscribed by the limitation of Section 34. And whenever you face a situation where you enter into a debate on the questions, on the evidence which are already appreciated by the arbitrator, then you have to keep your hands off.
That's right. That's right.
Because no evidence, vital evidence left out, or award takes into consideration an evidence which was not actually on the record.
Correct.
So these are the issues which you are, I think, being at the civil court, you are dealing with such matters on day in and day out basis. So for you, it may not be difficult to find out as to whether evidence is left out, or evidence, it is a case of no evidence, or it is a case where evidence which is not actually on the record, or it was brought on the record by one party, not supplied to other. And then the award is passed, and that award, that discussion on evidence makes an effect on the award, and it goes to the root of the matter. So for you arriving at this conclusion might not be a difficulty. But since I'm, as a Chief Justice, I'm dealing with the commercial court matters also, that roster is with me. So Section 34 orders come to me under Section 37 from the commercial courts. So, but then there is a request, and that request I'll make later after we discuss on that. But still nobody has asked a question about public policy. So I think you all are sure as to how you are going to deal with Mr. Mihir Thakur next time when he argues Section 34 before you.
Only one thing which I would like to suggest is that there should not be a complete hands-off approach.
Correct,
You have
correct.
to go into it.
Obviously.
Every district court has to go into it, then,
No one
yes.
Absolutely agree with Mr. Thakur.
No, before any question comes, Mr. Thakur,
See, please.
Sir, when the arbitral award is challenged on the ground of public policy, then how to distinguish whether such a agreement is used, this challenge is used as a sword or the shield? That only I want to know. The ground of public policy.
So as a last resort, are you trying to say?
But as a, whether it, how to find out whether this
How to
this ground,
distinguish
yes,
whether it is
distinguish.
taken only as a
Only for
shield
purpose, as a
to
shield, or
enter,
it is as
to
a sword?
get out of the award?
Yes, sir.
Or it is actually a sword
Yes.
which you can use
Yes, sir.
to slaughter the award?
Either side. Either side, sir.
Okay.
You'll always be welcome.
Yes, please answer.
I had a small question.
No, let this answer
See,
come.
if you go through the evidence, original evidence, and you find that certain evidence which are material are not considered at all, or findings are given on the basis of evidence which is not there, then certainly it is opposed to public policy, and you can look into it. And this is very clear from section 31(3) of the Act.
Mr. Khambata wants to add something.
No, before he says, no, I would like to have some kind of, yes, no.
In mind.
But Mr. Khambata, if you see Associated Builders case, where Justice Nariman has dealt with, the basic notion of justice and morality. And there is one illustration given. Say, for example, claimant had claim for, say, 40 lakhs in his claim. And the arbitrator is awarding, 100 or 120 lakhs. So Justice Nariman said that this is nothing but is against the basic notion of justice. Can we have some more instances for the understanding of the district judiciary? What can be fitted in within this concept that is against the basic notion of justice? What is that?
Certainly, for example, if no claim had been made at all on a certain area and the award has given a large award on that claim, or if no one had put it in the pleadings, no evidence was led, and suddenly the award is against your most basic notions of
Justice.
So there will be many cases, and that's the duty of a judge to sift. And as the learned Chief Justice said, that is the experience of a judge to be able to decide that there will be gray area cases. I, as a judge, trying to think of what I would do, I do find one area a little problematic. I can understand based on no evidence, that I think is easy. Based on evidence outside the record is also easy. But based on irrelevant material is very, very difficult, because then to judge the relevancy, you have to go into the facts and the disputes. How that is to be done. And I do believe that perhaps we have gone a little far in adding that to perversity. Because then you are asking a court to do a value judgment on facts.
Then are you not entering into an exercise of reviewing that?
Consideration, there's one question in my mind. Whether this concept of subjective satisfaction or dealing with the matter where subjective satisfaction is recorded on irrelevant consideration, whether that can be brought in?
I think, yes, I think we should pay attention to the word vital. Completely
Correct.
relevant. In fact, I think the formulation that Gaurav spoke about, they were thinking of manifest disregard, which is from Wilco and Swan, the US judgment. Then you have evidence staring you in the face and you don't take it. Or you go on some completely irrelevant evidence, but it has to be a standard. It has to be like a Wednesbury unreasonableness standard. It can't be that you just sift all the evidence and say, I think this is material. It should have been followed. Therefore, the award which we said, that would be very dangerous. Completely
Be there, but for that, sifting of the evidence has to be done. You have to sift through the evidence.
Yes, but you have to start from the fact that we are looking for evidence that could turn the entire matter the other way. Not just something to be thrown into the basket of evidence and give higher weight.
So sifting of evidence, not to take out grain from the chaff, rather to looking at
The root of the
going into the root of the matter. I think that is a distinction for sifting of the evidence. But as an appellate court, you sift the evidence in a way that you take out grain from the chaff. As a court under section 34, you will see whether after sifting of the evidence, like taking it away, it is flowing into the award, whether any error is such which goes to the root of the matter.
That's right. That's
I think this, to my mind, is the difference.
That's right.
That is the correct.
That's the correct. And just
I have a small question. From the point of view of a judge, when an award is before you. Now, this is my conception, and I may be totally wrong, that section 34 and 48, one is in part 1, one is in part 2. Basically, it's been pasted from the Article 5 of New York Convention. So, but otherwise, Chamsebara 1923 PV Council, which takes into account the first judgment, I think 1802 Eaton. So the principle of administrative law has come into private international law. And we have only one section or one yardstick. This is the pre-2015 position at least. So when it comes before a judge, the issue is what is the yardstick to be applied. If it is purely the Chamsebara principle, then you can broaden it a little bit. But when you go into private international law and you take Article 5 of the New York Convention, which has been put top down, then the aspect of the judging becomes a little narrower. So this is precisely the dichotomy which is faced by a judge, in my opinion. So what is your suggestion to that?
No, I think you've touched upon one of the core issues that is already developed and is definitely developing under arbitration jurisprudence. And which is, who is an arbitrator? Is he just a private party chosen by contract? Or does he fit into a larger public law space as an alternative dispute resolution mechanism? Western GECO said, no, he has to act judicially. There is a quasi-judicial public law element about him. And that has now been revived in the latest judgment in CORE, the electrification organization, which spoke of unilateral appointments. That balances or the tension between party autonomy on the one hand and the public, quasi-public position of an arbitrator on the other. And it is the latter which brings in administrative law concepts. It's a very vexed position, and that does put a judge in an invidious position. There's no snap solution to it. But I think if we go back to the statute as it stands today, there is enough guidelines for most cases. There will always be those difficult cases. For most cases, there's enough guideline. But yes, this is an area which is developing. And if we go all the way and say he's really someone who fills a public law space, then all the principles of administrative law will have to apply. In which case, then it ceases to be a consensual party autonomized process.
Good. So there was one more question. One question can be entertained, only one.
My question is in relation to that limited scope of judicial intervention. See, today there is a procedure prescribed and every stage has its own importance. So during the proceedings, suppose during the process of trial, something has been suppressed and that has come to the stage later on. So to that extent, see, there is a remedy available that you can go to 34, but that may or may not go to the root of the main issue. To what extent that judicial intervention is permissible? Because there is a remedy 34, but we are again going contrary to the object and intent of the act itself, that we are permitting the entire process to go again and again.
That's slightly debatable. Debatable in this wise. I think Mr. Banerjee will just give me a second.
Okay. So there is a very limited, this 227 window, which is sometimes used during the process. International ancestral law provided an appeal under section 16 to deal with some of these issues. I had written a letter to the APSHA committee suggesting that we have a 16 appeal. they did not agree with the then ASG. They said that if you interfere with the process during the process being on, then you defeat the
Intent.
I actually
You,
personally.
you ought to have written to expert committee.
Expert committee. Expert committee did not agree.
Oh, I
Justice
see.
A.B. Shah did not agree. There is some scope under the model law for a section 16 appeal. That is not there.
Which
So
questions?
as of now, on the merits, as of now, everything, the thinking seems to be, everything goes to the end. Whatever mess up you've done, whatever wrong has happened, everything can be
So
sorted.
machinery provisions are not generally interfered with. that.
34 stage, you have your one shot, whether, what, that seems to be the thinking of the legislature.
Thank you very much.
Our problem is that if at the interim stage, there is an interference, the whole arbitral proceeding will get delayed. And the matter interference is not merely at the 226 stage, it will go to the SLP stage also.
But then there will be a second round of
Yes, but
possibility of
that perhaps is
litigation.
the reason why nothing, no interference is called.
16 appeal, the issue was that it will go in appeal in 16. Either the judge will stay the proceeding or let the arbitration continue or cut it short. So that was the thought in the 16 appeal, but that has not been accepted.
Mr. Banerjee, let us imagine of a case. I think Mr. Thakur and I were, contesting. I am a claimant. There are certain basic documents on which my claim can be falsified. Those documents are the documents issued by the statutory authority. I am suppressing those documents. And you being the respondent, at the fag end of the trial, come to know about those documents. And if those documents are allowed to be produced, my whole claim will go in vain. But the High Court says, no, you must take up this issue at the time of 34. My question is, how will I take up that issue at 34? Those documents are missing.
I think.
Let Daras reply.
Look, there are cases and cases. And one doesn't have a complete magic wand answer for everything. We have to balance. And I think the committee at that time felt that the public policy in getting an arbitration to proceed outweighed the public policy that in an odd case, this sort of extraordinary situation would arise, because we lawyers are most ingenious. I sympathize and empathize with the judges. You have to hear us, both sides of the fence. And I've seen cases and cases where an arbitration is sought to be interdicted on some ground which ultimately fails, and 2, 3, 4, 5 years go on that. 16 is a jurisdictional question. So let's we have to separate the two. A jurisdictional question is usually decided either on the terms of the arbitration agreement, or the parties, or the arbitrability of the subject matter. None of these would fit a case of suppression of vital documents. So it's unlikely you'll get a case under 16 where vital documents are suppressed. I can't visualize one.
Can't be.
But I think you make a valid point. What if vital documents are suppressed? What is your ground under 34 then? I think if they are vital to the case and they would defeat the claim, for example, then that's certainly the most basic notions of justice.
Correct.
So if you have evidence in your possession, which is determinative of your case, you suppress that. Of course, that 34 will come in at that point.
Falling within that three categories, coupled with the latest judgment that judicial intervention, so far as the procedural, even substantive is not permissible, then procedural will be the bare minimum permissible, which is.
But I think even in Serosoft, a vital document, and vital means not just important, it means to the root of the matter.
Correct. So on which the whole claim can be frustrated.
Dismissed.
Frustrated.
Then of
It
course,
leads to frustration of the claim.
Section 34, it will be a question of public policy.
and justice
Correct,
is the
correct.
case. Most basic notions of justice.
So section 34 leads to a lot of questions,
Yeah.
I must say. And we can go on, or asking question and discussing with section 34. I think the whole day can be given to section 34. Justice Kulkarni.
I would have a very small question. Now, when we talk about public policy, we go to the Renu Sagar regime, the 1995, which is prior to the 1996 Act. Now, if you see the section, it uses two words, public policy of India. And in subclause 2, it says fundamental policy of Indian law. So many times I have seen that there has always been a confusion.
Yes.
And going by the Lord Borough principle and adding to it what Lord Denning had said. So please, can you just clarify on this, that public policy of India and fundamental policy of Indian law is creating a lot of confusion when it comes to actually testing the award at 34.
One is to go to Vijay Karya.
It's the same thing.
I think it is explained in the explanation.
In my view, the word fundamental is used only to emphasize the importance of it being something fundamental to our policy or common weal, not just an error of law. That's the word used even in Renu Sagar. So I don't think there is, to my mind, space between public policy and fundamental public policy. I think it broadly has to mean the same thing in this context.
In Renu Sagar, Justice Kulkarni, perhaps Renu Sagar wanted to establish a power plant,
Yes.
which entered into a contract with a foreign party. Then the question was about the payment. Renu Sagar said that I can't, transfer the payment. I am violating FERA.
Yeah.
So court said that provision was capable of being compounded. If you take a permission, then remittance will be done. So something which is like, supposing I enter into a contract with you, you are a foreign party, contract to supply drugs, which is prohibited so far as my country is concerned. Perhaps that contract will be against the fundamental policy law of India.
Quite right. But the problem is that if you see the judgment of Justice S.C. Agrawal in Renu Sagar, I think it is one of the most fantastic judgments one can ever read and reread.
That's right.
The whole concept of public policy has been discussed in the context of the enforcement of foreign awards.
Yeah.
And the concept of public policy as it is would come from the common law, as discussed in Renu Sagar. Now, this common law principles, only because we are aligning the law with the ancestral model, finds a place in section 34, that is possibly the perception.
Yes, that is.
So that our domestic arbitration law is actually meeting the global standards, because we can't have two different sets of parameters, of yardsticks to consider both the awards. Because if you see section 48 also has identical provisions.
That's right.
So
It has fundamental policy of Indian law.
Yes.
It has public policy, and it has public policy in 34 as well. So that is how we bring it at par with the ancestral model.
So far as public policy is concerned, that ground when taken, it has to have that standard of international
That is how
standards. That is how it is placed at par. And patently illegality is given for a ground for domestic arbitration only. And for that, I think our courts are well equipped.
Exactly.
The civil courts are better equipped than the High Court to deal with these arguments, I must say.
Yes.
Yes, I
The way you are trained, the way you deal with the matter since the beginning for over the period of years, by the time you come to man a commercial court where you are dealing with section 34, your mind is already trained. Just that restraint of temptation of being a civil court, entering into every issue, that has to be curbed, that's all.
So we
So-
accept.
So with this, we are running short of time. We have two more
we accept this,
topic
but
in this very session.
there is no difference then in public policy
I would-
and fundamental policy. So that should be the
Correct.
message to the judicial officer.
Thank you, Mr. Kulkarni. So there are two more topics, but I would still run through the questions which we have received by the participants who are online, and I will place all four questions together before the panelists, and whatever you want to answer, you can answer. The first question is, to what extent can a court under section 34 interfere with the heads or quantum of damages awarded by the arbitral tribunal? The second is that, is it open to a section 34 court to imply a term into a contract which is not present in an agreement or contract? And the third is, can the arbitrator consider prevailing business custom in interpreting a clause of a contract between the parties? And the fourth is whether there is need for a statutorily restricted meaning to be given to patent illegality as has been done for public policy. So these 4 questions are thrown to the panelists. I will show you if you want to answer one by one. It is on the screen.
I think 2, 3, and 4 have very short answers. I think
Right.
1 may have a little longer answer.
So I think we can start.
We start
one.
from the last.
So 2, 3, 4, you can answer first and then we can go to 1, which will take some time.
Arbitrator is required to consider the
Yes.
prevailing business practice. It is contrary to the business practice which is there, which
On-
is on evidence. Sir. If
Yes.
there is evidence of a prevailing business practice, he is duty bound to consider the clause as per the prevailing business practice.
4,
But there has to be evidence of that.
4, whether there is a need to statutorily restrict patent illegality.
I suppose so. If it is defined, well and good.
Okay. For 3rd, for 2,
The answer is no.
No,
This
answer
is-
is no.
100%.
100% no.
now we come to 1.
Actually, this is a major problem
Yes.
that contractors are facing. And there has been a lot of to and fro on this. Earlier, the understanding was it is a matter of evidence and court should not interfere. Now, after the judgments in Bartley Boy and Unibros, the Supreme Court seems to suggest that insofar as quantum of damages is concerned, there is a certain degree of proof that is now required, without which the awards will be set aside.
But both these are under the old
Volume बढ़ा दो.
pre-2015 regime.
Volume.
मैम हॉल में बहुत ज्यादा मॉनिटर्स है ना इसलिए आपको डाउन सुनाई.
So there are now cases that the last 2 or 3 judgments of the Supreme Court in Bartley Boy Unibros, they are interfering and they are setting aside awards on the basis that there is no evidence in respect of loss of profitability, etc., which was not the understanding a few years ago. So you can actually scrutinize quantum of damages to that extent.
So the last question on section 34 of mine is, and you can briefly explain that, what parameters should a court under section 34 consider while dealing with an arbitrator's interpretation of onerous clause in a contract on the touchstone of patent illegality?
Okay, in the interest of time, I'll keep this very brief.
Right.
Normally, an arbitrator's interpretation of a contract is something which should not be interfered with by the court. There have been a peculiar situation where some government contracts have clauses which say, regardless of responsible, if there is extension of time for delay, there is no question of giving any compensation. Such clauses have been, there are 2 lines of judgments both ways, but the prevailing view, there's a recent judgment of the Delhi High Court, which seems to suggest that if that is the clause that you have agreed to, that is the clause that you will have to live with, and you should take up the point earlier. Normally, unless it is, we go back to patently illegal, whatever the arbitrator has done in terms of interpretation, you're not supposed to substitute your own thinking for that.
Only one question. Supposing the contract contains certain clauses like exclusion clauses or non-arbitrable clauses, can arbitrator say that this particular clause is against the provision of the Contract Act and therefore damages should be given? Delhi High Court has recently taken a view. Otherwise, whatever we agree as parties, one should not go beyond that.
Simplex is no longer good law. There is now a judgment of Justice Bakru in, I think, +91, where he suggests simplex is not good law. If it is a question of arbitrability, then it's a question of jurisdiction.
I quite see.
So that is a different head of challenge under 34, that you are beyond your jurisdiction. 34, in fact, 34.2 has a separate subhead which deals with non-arbitrable cases. But otherwise,
Like you may not be, entitled to any ideal compensation, ideal time compensation, or the
So-
escalation clause,
I
something
may-
like that.
I may be excused now to move on to the next topic.
Go ahead.
Because that is also we have two experts on two sides who have actually argued this matter.
Yes, could be.
So question is about modification and severance of arbitral award. So I would request Mr. Darius Khambata to give his brief introduction on this.
So this is the Gayatri Baraswamy decision of the Supreme Court. It's generated a fair amount of controversy and criticism. But I don't think when I read and reread it that is justified. And Gaurav and I actually, when you read the judgment, were not completely opposed to the result. And I'll explain what. What was the Supreme Court grappling with? It found, as you've seen in so many cases, that parties, especially individual litigants, impecunious litigants, go through an entire trial and process of arbitration lasting several years. And at the end of that, sometimes on just one point, the award is set aside and they have to start all over again. Now that is something that many would find daunting. They would give up their claim. And it certainly defeated one of the primary objectives of arbitration, which is finality. There is no express power to modify an award in a 34 court. So what does the 34 court have to do? If it follows strictly the letter of the law, it would just say award set aside, go back, restart the arbitration. And this might happen at the 37th stage. This might happen at the Supreme Court stage. The flip side is that if you allow a 34 court to modify an award, you are making it a court of appeal and you are opening the floodgates. So on this vexed issue, Gaurav was more in favor of the strict approach, and I was in favor of a very slightly attenuated modification approach. I also agree and agreed even when I argued that please do not read in an unrestricted power of modification. That won't serve the objective. Now, what the Supreme Court has done is it said that look, today, by the black letter law of the Act, there are only 3 remedies under the Act. Section 33, which gives you 30 days to take the award back to a tribunal for typos or clerical error. Very restricted power. 34(2)(a)(4), which allows you to sever an award, provided that part goes beyond jurisdiction. So only on jurisdiction severability. And third was 34(4), which allows you to remit the matter back to the tribunal. The Supreme Court, in the iPay judgment and before that, Dyna Technologies had given a very restricted meaning to 34(4). That you can send it back, but only to fill up gaps in the reasoning, not to supply fresh reasoning, etc. Faced with this conundrum, by a majority decision, the Supreme Court has said that the power of judicial review under 34 includes a limited power to modify. But that power to modify must be exercised strictly within the guardrails of Section 34 and within its confines. Secondly, it recognized that there was, and this they said all sides accepted, which they did, there was a general power of severance. Now, we've seen many awards where the bad portion is severed. It's not necessarily only on the grounds of jurisdiction, which is all that the Act provides. So a general power of severability has been widely accepted across the country as existing, so you don't find any particular provision that says you can do that. And the Supreme Court said, in that judicial review power under 34 and the power of severability, we find an inherent power in a court to modify, but on what cases? And the test, and of course, this is not the time for a very detailed analysis. But the test is found in para 46 of the judgment. And the test is that a modification will be appropriate only where it follows inevitably from the tribunal's determination of a question of law. We've been discussing patent illegality. Take the easiest case. The wrong article of the Limitation Act is cited by the tribunal to dismiss a claim. Otherwise, there is no dispute of merits that the amount is created. If the 34 court finds that no, the correct article is this one, and in which case the claim would be allowed, that is a limited area of modification permitted. And that modification cannot involve going into re-evaluating the merits of the matter at all. The second major thing that Gayatri Balaswamy has done, and on this there's no dissent, because both the dissenting judgment and the majority have concurrence, and sometimes this is overlooked, is 34-4. Both have said that 34-4 effectively is a safety valve. That's the expression used by Justice Vishwanathan in his dissent. And the majority has said a 34-4 remission must give the tribunal full scope to remedy the defect, and including by taking of additional evidence if required. It still doesn't permit the tribunal to rewrite the award. It still doesn't permit the tribunal to award a claim which we have not awarded earlier. But in terms of what they've already done, they can, even in a given case, if necessary, take additional evidence and give their final award on a remission. And the remission will be always by a 34 court as to a specific aspect. It won't be a general open-ended remission. That's what the Supreme Court has said. Now, this is, therefore, I urge this as a very, very narrow and restricted power of modification. It's not a general power, and it should not be used as a sledgehammer to just either send matters back or to modify like an appellate court. It is not meant for that. The Supreme Court, I think, has categorically said that the counsel who argued the arguments made for a general modification, which thankfully I did not argue, are rejected. That has been categorically rejected. I would not have been comfortable arguing for that, because that wouldn't have been subservient to the objects of the act. And therefore, the Supreme Court says use it like a sculptor working with a chisel. I would use the example of a surgeon with a scalpel. It's not a sword to slash through an award and rewrite the award. It's in a limited case. If there is a question of patent illegality which you have found, this is the correct law that should have been applied, and without then re-evaluating merits or going into evidence, you can say then this should have been the result only in those limited narrow cases, and I believe they'll be rare. I don't believe that they should occur. In those cases, the Supreme Court has said there is this power of modification.
Limited.
Right? The dissent is a very well-written dissent, the powerfully argued dissent. But the majority has come to this conclusion as a public policy objective, and I think the ball is now really in our court, whether as lawyers we stick to this discipline and whether as judges stick to this discipline. That is really the test that we await.
So my question is to Mr. Gaurav Banerjee. Would you like to elaborate on fog of uncertainty used in the judgment?
So I will elaborate on that, and I will respond to what Darius has said. As you can realize, I was on the other end. We were arguing not for such a power, but I have, for the purposes of this discussion, again, read and reread the majority judgment. And there are 4 or 5 paragraphs where what Darius says is absolutely correct. The idea is to have a very, very narrow and limited power. So as a judge, earlier the choice was clear. Either you uphold the award or you set aside the award. That was the binary choice that you had. Of course, subject to severability. The test earlier was that supposing you had an award which could be carved up into, say, 10 different awards, and one award was bad, you could then uphold the rest of the award and set aside the 10th award. That was the understanding earlier. Now, as a judge, when the 34 petition comes before you, you have many choices. there's a plethora of choices. You can, of course, uphold the award. That would be possibly the default mode. You could set it aside if, as Chief Justice Khanna says, that the award is such that it cannot be corrected at all, then you set it aside. Then there are at least two other aspects which have now been highlighted in the majority. One is the Section 33 power. The 33 power is a very limited power. It's still with the arbitral tribunal, which is like 152 CPC typographic corrections. But what is interesting about this judgment is that two further options are given to the judges. One is you remand under 34.4 or you modify. So 34.4 remand was already there, but it used to be interpreted very narrowly. Now that interpretation 34.4 has been slightly opened up, which I believe is a positive thing. I think the earlier judgments read it very narrowly. 34.4 has been positively opened up. Now the question is, what about this power of modification? Obviously, there were differences of opinion. Supreme Court has taken a pragmatic rather than a principled view and said, yes, you can modify. And that is the law today, and that is what the courts will be required to follow. Now, the only issue here is, when can you modify? Now, we heard Mr. Khambata say, and he did argue that it should be very, very limited. It should not amount to entering the merits, and it should be, there should be, as Chief Justice says, there should be no fog of uncertainty, for the phrase used by Chief Justice Khanna. If you are dead sure about the result, then you can modify. Otherwise, your option is to remand or to set aside. The issue here is that, having said all these things, as a lawyer, I will always come up to you and say, my lords, okay, I accept, it's a very well written award. Now just tweak this little bit for me and I'll be happy. Just, this claim, just modify it slightly. This is exactly what has happened in the Delhi High Court. After Gayatri Balasamy is cited, all the guardrails mentioned by Mr. Khambata, in 3 lines, the award has been modified. So that is one thing that you need to protect yourself against. There are 5 or 6 paragraphs. It is impossible to summarize it, but I think there are enough indicators in Gayatri Balasamy in the majority from paragraph about 52 to 56, which explain when you can modify, when you cannot modify, when you can send back, when you cannot send back. But my only earnest appeal is that that should be held to, and what is happening now should not happen. That's correct.
One more question. You said that when there is no uncertainty or doubt, and the court under Section 34 is dead sure that this should be the outcome, or this should have been done by the arbitrator on a set of whatever material is before it. So it can modify the award.
But the next sentence says you can't rewrite the merits.
Rewrite the merits.
So, I mean, it's a very small.
So again, there is a Lakshman Rekha, which you cannot cross.
Correct.
So you have to create a kind of restraint for you.
Correct.
As to what extent you can start. Like lawyer will take you to the other side.
Absolutely.
Definitely. But you have to, while moving, you have to stick to this line and not crossing this, beyond this.
Sometimes calculations go wrong. Sometimes there's an obvious error. Somebody has asked for, say, X claim, and you've given some greater claim. Then, and even the claimant says that was not my claim. So if you can tweak it, it is better than setting aside and setting it right.
So this
2, 3 very unusual circumstances.
So this uncertainty or doubt, like this concept, is whether this concept is also for the demanding the award under Section 34?
No.
No. Because the power is already there.
Power is 34.
34.4 is there.
Correct. So 34.4 also, again, you cannot remand by you again, it's also a limited power. But if you have a fog of uncertainty, you have two choices. One is you set aside the award. If you feel that you can't remand to the same tribunal because they'll be embarrassed, etc., you set aside the award. Or if you feel you can send it back for a very limited aspect to be tweaked, you can remand. But again, very narrow.
So the words used in 34(4) is will eliminate the grounds for setting aside the award. So remand is for the purpose to eliminate the grounds for setting aside.
Very important point, ma'am, you made. All this of modification or remand or setting aside, first you have to establish that the award is vulnerable.
Correct.
It should be set aside. Only then do you go. Normally you uphold the award. So
Right.
first step is set aside.
Vulnerability. Unless and until it is vulnerable, you will not go into further inquiry.
Either you say the award is good by and large, or if you will first have to make out a 34 ground in your mind and then prima facie and then go down this path.
Anything more you want to add, Mr. Diraz?
I completely agree with Gaurav. Really, the test is we should keep it to as narrow as possible. That's what the Supreme Court has said. The Supreme Court has not said there's a general power modification or interference, and we should respect that. And then good will come of it, because in those few cases where injustice results from sending the party back, and the position is as clear as the Supreme Court said it should be, only in those few cases should that power be exercised. The good thing is the 34(4) part. Because now all those restrictions that the Supreme Court itself had put on the power of the tribunal seem to have been lifted. So 34(4) can in fact that would be the preferable option in most cases. Unless, as the Supreme Court says, it will be invidious or embarrassing for the tribunal or time consuming. 34(4) is now a very effective option. That send it back, they can even take further evidence, but send it back with a specific direction as to which aspect has to be reconsidered.
So we have one more topic, but there is a crisis by the reins. We have this section 37 topic still. So I would request Justice Kokji to sum up in 5 to 10 minutes on section 37 because of rain, there is some crisis in the dining area, food area. So we can't continue for a long time.
Thank you, Chief. Is it audible?
Is it on?
Thank you, Chief. There is a prelude to the topic of section 37, and that is because the majority participants are the judicial officers, and the tendency by way of our training or our job profile, we usually tend to turn towards adjudication. Now, adjudication and arbitrations are two different principles, though they are intertwined, but always the tendency as a judge would be to turn towards adjudication. And adjudication means lot of processes, whereas arbitration is less of processes, more of practical choice. And therefore, whenever a proceedings under an arbitration comes before a judge, he has to wear the hat of an arbitrator and not that of an adjudicator. With this prelude, I would take up the section 37, which is a standalone provision in the chapter number 9 of appeals. And section 37, it prescribes which are the orders which are appealable. Now, this section is divided into 3 parts. The first part is where a pure adjudication will take place. Like in the sense, the first part is for the purpose of taking up the orders which are passed by a judicial authority or a court. Whereas the second part, subsection 2, is pertaining to an orders which are passed by arbitral tribunals. And third section, which today will not be relevant because it prohibits any further appeal. The first part, if you see subsection 1, the subsection 1 also has 3 subsections, and the first section of subsection 1 of 37 is purely adjudicatory process. Like we are dealing with section 8, an order passed under section 8 for the purpose of referring to arbitration, if that arbitration reference is based on an arbitration agreement, and that there are other criteria under which are provided in subsection 2 fulfilled, then there has to be an arbitration. But if the order is required to be interfered with, then it is purely an adjudicatory process. But when it is with regards to subsection 2, which covers interim measures, and those interim measures which are provided under section 9 and section 17, 17 by the arbitral tribunals and 9 by the court. In that eventuality, more of discretion is required to be exercised as against adjudication. So when you are exercising discretion, you have to weigh to which side our discretion should be exercised. And if that be so, then the challenge which is made under 37 will have to examine what are the discretion, how the discretion has been exercised. So that is the limited applicability of section 37. Now, there is always a question always hidden in this is that to what extent section 37 go if it's an order which is passed under 34. In my opinion, the section 34 and 37, the powers which are required to be exercised are coterminous. Like in section 37, when you are examining an order of section 34, you can't expand the scope. Rather, the decisions of the Supreme Court is that when you are exercising power under section 37, those powers have to be narrowed down to that of section 34. Before I close my opening statement, there is one lurking question which I'll request the panelists to address, is that of limitation for section 37. Now, 34 in itself prescribes a limitation, but there is no such limitation in section 37. So in that eventuality, is there any pronouncement or is there any provision which should govern the limitation for referring an appeal under section 37? Because if we apply Limitation Act, then there are 4 articles which deal with appeals in the Limitation Act. And first two articles, Article 114, 15, they are dealing with the criminal law. And Article 117, they are intra-court appeals. So it lives with only Article 116 only, which provides for an appeal, but that is applicable only to provisions of CPC. So my request to the panelists is to dwell upon this issue and guide us. Thank you.
I suppose Mr. Gaurav Banerjee wanted to answer this question.
There is a judgment.
There is a judgment of the Supreme Court.
By the Supreme Court sometime in 2021. I will just, I don't remember it all right. But these are the covered records. Yes. Intra-court appeal under the Commercial Courts Act, that limitation would apply for the 37 appeal is what I vaguely remember is the law.
But it's only when there is an intra-court appeal where it's possible in Delhi or in Bombay. But the court in Ahmedabad does.
We have 34 at the level of the district judiciary, and that is a commercial court. And 37 commercial division is High Court. 37.
There are
Any appeal under the Commercial Courts Act.
So,
13 is quite.
but then there is a caveat, I suppose, which says that the court has to be very, very cautious, and the cases where only proper explanation is given in exceptional circumstances, the appeal is not filed under section 37 within the period of 120 days, which is provided under section 34(3). 34(3) talks of an inelastic period of maximum 120 days.
I can only say this, that as often happens in court, your lordship has stumped us.
The judgment I was referring to a 3-judge bench of Government of Maharashtra and Borse brothers under the section 37, where
the words used are exceptional case. Beyond 120.
Beyond.
Any 37, I think there is one question from the virtual participants. Should different considerations apply to section 34 appeals arising out of orders under section 17 as opposed to orders under section 34. I think this question is relevant for the district judiciary as well, because against orders under section 17, 37 appeal is filed in district judiciary in Gujarat. Am I right, Mr. Thakur?
Yes, yes.
So 37, so far as district judiciary is concerned, in Gujarat, 37 goes against an order passed under section 17. So, Mr. Thakur, would you like to answer this?
I think section 17 appeal is an appeal against an interim order of the arbitral tribunal. Therefore, the scope of interference would be in the context of an interim order.
Correct.
39,
43
yes.
appeal.
Nature of order 43. And it's only for the purpose of seeing what should be the protection during the pendency of the appeal. 34 is narrower and it will have to be decided on the basis of section 34 principles only.
Yes. So 37 is narrower. Principles cannot be applied beyond the limitations of section 34. And it is more narrower, like more than section 34, because it is a second round of inquiry by the court under section 37. So this discussion, I'm thankful to I must extend my gratitude to all the panelists for enlightening the audience in such a very, like, the expression during the entire discussion was so beautiful that I was also taken away with how they describe about each and every topic. So thanks to Mr. Mihir Thakur, thanks to Gaurav Banerjee, thanks to Justice Kopje, thanks to Mr. Kamal Trivedi, and thanks to Darius Khambata. Thank you for joining us. And I would just like to close this discussion, because what they have done, I'm not supposed to add anything. I would just like to add and end this with that whenever we are dealing with section 34 as a district court, or 37 as a high court, or 37 again as a district court against order under section 17, we must put a question to ourselves. And that these three questions are we treating the matters relating to arbitration like any other civil proceeding? And this applies to lawyers also, arguing and trying them as a routine litigation in a manner that results in the frustration of its core principles and the object. The second question is whether the parties who are entangled in the layers of litigation will lose control over their dispute because of the delays at our hand. If we are able to answer this question while dealing with the dispute at the very inception, I think we will be able to uphold the spirit of object and spirit of the Arbitration Act. And it should be our joint endeavor to uphold the spirit of codified law so as to promote the culture of dispute resolution, which is grounded in trust, efficiency, and professionalism. Thank you so much.
Thank you very much, Chief.
With that, we conclude the first session. And before we part, may I request Honorable the Chief Justice to felicitate our distinguished panel members. Firstly is Shri Kamalbhai Trivedi. I request Honorable the Chief Justice to felicitate Shri Darius Khambata. May I also request Honorable the Chief Justice to felicitate Mr. Mihir Thakur. Lastly, if the Honorable Chief Justice may felicitate Sir Gaurav Banerjee. Thank you very much. With this, we break for lunch and we shall reconvene exactly in 35 minutes from now to start the next session. The time is at 2:35. It's 2 o'clock right now. We reconvene again at about 2:35. Good afternoon, everyone, and welcome back. We have with us the distinct and distinguished panel for this second session in the form of Honorable Ms. Justice Hema Kohli, former Judge of Supreme Court of India, Honorable Mr. Justice Girish Kulkarni, Judge, Bombay High Court, Honorable Mr. Justice A. Supaiya, Judge, High Court of Gujarat, Honorable Mr. Justice Sabyasachi Bhattacharya, Judge, High Court of Calcutta, Senior Advocate and former ASG Mr. Balbir Singh, and Senior Advocate Mr. Ritin Rai. May I request Ms. H.M. Pawar, Member Secretary, Gujarat State Legal Service Authority, and Mrs. A. Vyas, Joint Secretary, Gujarat State Legal Service Authority, to kindly escort the dignitaries on stage, please. Good afternoon, ma'am. Hello, sir.
Welcome, sir.
Hello, sir. Yes.
Before we start with the second session, we'd like to introduce the panel and the chair. It is indeed a privilege to have amongst us Honorable Ms. Justice Hema Kohli, an outstanding jurist whose legal journey has spanned over 18 years at the bench, including her time as the former Supreme Court judge and the first woman Chief Justice of the High Court of Telangana. Justice Kohli's commitment to alternative dispute resolution is exemplary. She played a pivotal role in establishing the International Arbitration and Conciliation Center in Hyderabad and is an accomplished arbitrator registered with SIAC, Dubai International Arbitration Center, Indian Council of Arbitration, and the India International Arbitration Center. Her role as a founder-term trustee of the International Arbitration and Mediation Center, Hyderabad, is especially significant for this conference, as the center stands at the forefront of promoting institutional arbitration and mediation in India, directly aligning with our discussion on fostering arbitration's core philosophy and procedural integrity. From defending public policy and grappling with patent illegality under Section 34 to promoting the balanced role of appellate courts under Section 37, Justice Kohli has contributed to evolving our understanding of arbitral award enforcement and modification. Her international recognition as a certified specialist mediator and panel member on leading arbitral bodies brings a global perspective to this forum. Justice Kohli's wealth of experience and visionary perspective will guide our conference's dialogue, ensuring these complex issues are discussed with nuance and expertise. It's an honor to have you with us, Your Ladyship, and we look forward to you leading the session.
Our first panelist for this session is Honorable Mr. Justice Girish Kulkarni, who is a sitting judge of the Honorable Bombay High Court since January 2014. Known for his firm yet fair judicial temperament, Justice Kulkarni has made a significant impact in adjudicating complex commercial and arbitration matters. His judgments have emphasized that arbitration clauses are not to be treated as mere formalities, but as binding commitments reflecting the will of the parties. He has upheld the autonomy of parties to structure their arbitral process under Section 7, 10, and 11 of the Arbitration Act, and has also underlined the limited scope of judicial inquiry under Section 8 of the Act. His decisions reflect a careful balance between judicial interference and respect of arbitral tribunals' competence under Section 16 of the Act, thereby promoting efficiency and fairness in the dispute resolution mechanism. His judgments reflect a nuanced interplay between courts and arbitral tribunals. Justice Kulkarni's decisions overall illustrate strong support for party autonomy, limited judicial interference in arbitration, fair challenges to arbitration, and upholding arbitral tribunal competence, reflective of statutory framework under the Arbitration Act. Thank you, Your Lordships, for taking out time and being with us today, despite there being a working Saturday at the Honorable Bombay High Court.
Next on the panel is another distinguished judge of our High Court, Honorable Mr. Justice A.S. Supaiya. My Lords is known for his judicial acumen and dedication towards the institution and its integrity. Justice Supaiya has earned respect for his balanced judgments, notably in civil and commercial laws. Justice Supaiya's rulings have reinforced the mandate for time-bound dispute resolution in arbitration and held government-appointed arbitrators accountable for undue delay in such process. Justice Supaiya is committed to the constitutional values and judicial fairness, which is reflected in his decision-making process. We welcome Your Lordships, to this panel.
We have our next panelist, Honorable Mr. Justice Sabyasachi Bhattacharya, a sitting judge of the Honorable High Court of Calcutta, which brings a wealth of experience from his days as a leading civil and constitutional lawyer. His transition to the Calcutta High Court bench was marked by clarity, sensitivity, and keen focus on procedural integrity. Justice Bhattacharya was designated as a senior advocate in 2014 and was empaneled as a special counsel for the central government of India from 2015. He practiced for over a span of 2 decades before ascending to the bench in 2017. With deep expertise in civil and constitutional law and valuable experience as a court-appointed arbitrator, Justice Bhattacharya brings invaluable insight to this panel. Justice Bhattacharya approaches every arbitration with an eye for practical fairness, whether breaking new ground on patent illegality or navigating intricate procedural questions. My Lord's judgments are respected for thorough readings and succinct reasonings. We welcome you, Your Lordships, to the panel. Thank you very much.
Next on our panel is Senior Advocate Mr. Balbir Singh, who is a distinguished lawyer and a former Additional Solicitor General of India. Sir has an illustrious career spanning over approximately 3 decades in the top courts of India. Sir is widely respected for his expertise in corporate law, taxation, regulatory litigation, competition law, and arbitration. He has appeared in numerous high-profile cases involving domestic and international dispute resolution. His experience as ASG involved representing the Government of India in sensitive and complex matters, adding to his exceptional understanding of public and private law intersections. Sir has promoted the creation of a trained pool of arbitrators and specialist arbitration counsel, both Indian and international, to support efficient and expert resolution of high-value disputes. He has also contributed extensively to legal education and discourse, sharing his knowledge through lectures and articles in reputed forums. His holistic engagement, blending high-level litigation, policy advocacy, institution building makes him a major contributor to the evolution of arbitration law and practice. We are privileged to have him with us today. Thank you, sir.
Last but not the least, we have the pleasure of having Mr. Ritin Rai, Senior Advocate, who is a leading figure in commercial and regulatory disputes with special expertise in arbitration. Educated at Delhi University and Oxford and Harvard Law School, He began his professional journey at Jones Day in Cleveland before returning to India to practice corporate law. In 2004, Sir transitioned to a successful independent disputes practice, often appearing before the Honorable Supreme Court of India and various Honorable High Courts across the country, as well as before the arbitral tribunals. Mr. Rai's practice spanned complex company, competition, insolvency, and telecom matters, and is particularly respected for handling high-value arbitration cases across the country. He frequently serves as both as an arbitrator as well as counsel, and has experience with ICC, SIAC, and ad hoc arbitrations, including appointments by the Honorable Delhi High Court. Internationally, he has acted as Indian law expert before foreign courts and forums, further expanding his reach in global commercial arbitrations. Mr. Rai's work as counsel over the years has helped clarify free arrangements for arbitrators, enforce party autonomy, interpret the jurisdiction of arbitral tribunals, and define court interventions in the arbitral process. Known for sharp strategic insight, Sir actively contributes to discourse on arbitration reform and is sought after for his perspective on why Indian dispute migrates to foreign seats, advocating for efficiency and timely resolution within India's arbitral institutions. Thank you very much, sir, for taking out time today and being with us. We welcome you to the panel.
May we now request the chairperson to take the discussion forward.
Very good afternoon to all of you. They always say that the session after lunch is a challenge for two reasons. One is on a full stomach and not too keen to hear pontification from the dais. And the other is the subject becomes more convoluted because patience is a bit low by the second half of the sessions. So we are going to struggle with it and hope to keep it alive and active. One of the things that we had thought that we had planned to do, and let me congratulate and compliment the Gujarat High Court, the Academy, and all the lawyers associated with Honorable the Chief Justice as a patron, who made sure that we all had our virtual sessions with each other before we came before you. So we had that preparation and we knew each other well enough to know how to run this thing and make it as smooth as possible, which is really a matter of ease. And talking of ease, the focus of this court and this conference is ease of doing arbitration. Why the importance of arbitration? When the government talks of doing business with ease of doing business with India, let us not forget it means that there are foreign entities that are coming to us. They are coming here to do business, they are coming here to do industries, they are coming here to make investments. All very well. But after they come in and make an entry, it is natural in any trade, business, or industry that there will be disputes. And when disputes happen and parties arrive at a closure, the ease of exiting should be equally good. So ease of business just doesn't mean ease of entering into a country with business. The ease of moving out makes it a more attractive jurisdiction for business to be done effectively. And that is where the judiciary comes in. So this constant focus that the whole 2 days will be doing on arbitration has a meaning. There's a method to this. That all of you judicial officers who are the courts of first instance must be aware of how to run an arbitration dispute and what should be the ease of exit, just as there should be an ease of entry. In other words, if there is an award, to make sure that it is implemented as quickly and as effectively as possible. And if there are throes of matters where matters are pending before the arbitrator, to make sure that the process is hastened. The rest will follow. And it is that we bring to you today in this conference. The fact that you have to handle arbitration matters in a particular manner, the ethos of arbitration, the expedition of arbitration, the efficiency of arbitration is what we are talking about. This is the sum and substance, the heart of the matter. Coming to our session, we have some distinguished speakers. I'll just open up and touch upon the subjects and leave it to the speakers then to speak, and emphasis again on timelines. We are being told arbitration takes a lot of time. Well, our sessions will stick to the time. We'll make that effort for you. So distinguished panel members, esteemed colleagues, judicial officers, most of all, Honorable the Chief Justice, who's sitting here with her colleagues right in the front bench, so patiently and supporting all of us through this conference, her team of judges. We are so happy that we are able to join in today, not only physically as we are in the auditorium, but also online. It is a pleasure to open this session with a panel discussion on some of the most vital subjects. Now, we've been dealing with 34 and 37 and all of it, which is the pre-lunch session. What will we focus on now? Our focus is going to be on the key provisions of Part 1, and particularly they are spread across Chapter 2 to 5, that is Section 7, Section 10, 11, 19, 18, Section 20, Section 8, Section 16, Section 12 and 13, which are interrelated. Each of these provisions raises practical questions that our courts have to answer and the tribunals are still grappling with many times. And therefore, this diverse panel that we expect will unravel all this for us. So just as an introduction, topic 1, which Brother Justice Kulkarni will address, is Section 7, Section 10, Section 11, and Section 19, party autonomy, understanding the legal framework. Section 7, as we all know, defines arbitration agreements. Over the years, our courts have clarified its essential features. It has consistently emphasized intention of the parties is the key. Even if the wording of the arbitration clause is imperfect, as long as the intention to submit themselves or their dispute to arbitration is clear and unambiguous, the clause should be given effect to. That's the underlying principle. At the same time, the words used must reflect that mandate to arbitrate. So clauses which say parties may go to the court or parties may go to arbitration would not perhaps meet the requirement of 7.1. The agreement must be clear to demonstrate parties had committed themselves and resolved that their disputes must go to arbitration as the mode of dispute resolution. Agreements must be in writing. I'm not going to let brothers touch on all this because this is something we are all assuming you know when we come back. He'll be doing the nuanced discussions with you. Agreements may not necessarily be signed even if they are in writing. And under the doctrine of separability, the arbitration clause stands independent of the main contract. There are several decisions that will be thrown at you perhaps in the course of our discussion. Section 10 that allows parties to determine the number of arbitrators, always odd and never even, we know that. Section 11 that brings in the role of the court in appointment of arbitration. Section 19, the determination of rules and procedure that reflects party autonomy and the freedom of the parties to decide what should be the procedure. But the underlying guiding principles must always be principles of natural justice, equal opportunity, and fairness to prevail above all. Topic 2 will be relying on Justice Supriya to enlighten us on that, equality principle in arbitration, covered by Section 18, and party autonomy, understanding the legal framework under Section 20. Section 18, equal treatment of parties, that places the principle of equality at the core of arbitration. This provision makes it very clear that parties to the arbitration must be treated alike. When we say alike, let us not forget, in our courts, the jurisdiction is many times where we have government as a major litigator before us. So no special treatment is what is being emphasized when we say parties to be treated alike. Even when the government is a party, the principles of equality must be visibly seen to be and demonstrated. And then again, both sides should be given an equal opportunity, not only during the course of the proceedings, but also at the time of appointing the tribunal. We know the decisions now and how it can't be one party selecting an arbitrator and the other one falling in line. The dominant party principle no longer applies. That is what we are saying. Section 20 addresses the place of arbitration. Brother Supriya is going to tell us about what are the words like place, like venue, like seat. Are they interchangeable? Are they not? How are they to be treated in the language of arbitration? Topic 3, power to refer parties to arbitration under Section 8. Brother Sabyasachi Bhattacharya is going to address us on this. Section 8, scope of inquiry by the court. the Section 8 that deals with power to refer parties to arbitration where there is an arbitration agreement, emphasis on that. The design of the provision is clear. The role of the court to refer the parties allows only after an application is moved. Courts on their own, suo motu, will not be able to exercise this power unless somebody applies to the court. For such a purpose, it is not a self-executing provision, if I may say so. Equally important is the timing. When should the application be moved? What is the appropriate time? If it is late, what will be the effect? All of it, and whether a reference can still be made in cases that have been subject to repeated judicial scrutiny. We'll discuss this aspect. Mr. Balbir Singh, Senior Advocate, is going to talk about the principles of competence under Section 16. This is that statutory recognition of this competence principle that the arbitral tribunal has the competence to rule on its own jurisdiction. This is important for judicial officers, that at what stage should the courts interfere, at what point, what are the issues the court should deal with, and what are those that should be left aside for a tribunal to decide without any interference from the court. If the tribunal rejects a jurisdictional objection, it is required to continue the proceedings. So, tribunal will decide, tribunal will continue. If a party has an objection, invariably they are told by courts, hang on, wait, let the matter be over. You have that right in 34. Take all the pleas available to you then. But don't keep rushing to court to break that procedure. So the design is deliberate. Minimum interference by the court to ensure that the arbitration runs its course, right? Then we come to topic 5. Mr. Ritin Rai, Senior Advocate, will be addressing us on challenging the arbitrator. Section 12 and 13. 12 and 13 are treated as the safeguards of the integrity of the arbitral process and ensures that arbitrators are seen to be independent and not just independent. Emphasis is seen to be independent and impartial. We do have soft rules also to support it, but Section 12 and 13's interplay, read with 5th and the 7th schedule, is something that Mr. Rai is going to talk about. The full disclosure by the arbitrators at the time of appointment, no biases, lack of biases, the fact that there could be justifiable doubts about the arbitrator's independence or impartiality. These include direct or indirect relationships of the arbitrator with family members and such like. Section 13 sets out procedure for challenging the appointment of arbitrator, a challenge that must be raised promptly. How promptly? Within 15 days. This is something we will have to discuss and understand, because these are issues you will be grappling with. The test ultimately is, and as the Supreme Court has been saying time and again, is not whether bias is proven, but whether a reasonable third person who knows the facts of the case can have justifiable doubts about the impartiality of the arbitrator. That audience is the bottom line. So these are standards. Why are these standards? To do what? To protect the integrity and the credibility of the process of arbitration. If that is protected, then frivolous challenges and tactical such interventions should not be entertained by none other than you as courts. That is the bottom line. I'll start now the discussion with Brother Girish Kulkarni. I'll request him to address us on the provisions that we have just discussed, 7, 10, 11, all of it, and 19, Girish. Thank you.
Very good afternoon. At the outset, Honorable the Chief Justice of the Gujarat High Court, Justice Agrawal, learned brother and sister judges of the Gujarat High Court, distinguished members of the District Judiciary, lawyers, the chairman of the session today, Justice Hima Kohli, Brother Justice Bhattacharya, Justice Sophia, and the panel members, Mr. Singh and Mr. Sen. Mr. Rai, sorry. I must congratulate the Honorable Chief Justice, because to have such a gathering and to discuss these issues, I feel not only as a student of law, but also as a judge, it is very important, because the subject is so evolving. I think insofar as our country is concerned, arbitration law is not new to us. As Justice Anjaria pointed out in the morning, it is there with us since 1772, which is about 252 years. But why do we feel that the arbitration law is so new? And every time we want to have discussions on the nuances, on the new developments on arbitration law, I think the credit goes to we at the bar as also the judiciary who is confronted with these issues, the evolving business we have, and the peculiarity, I would say, of the arbitration what we have in our country. The diversity in the businesses, the more inclination of the parties to go for arbitration, the reach of the arbitration to variety of levels, I would say, that even I gave an example when we assembled last year in Delhi to a Mama Bhanja agreement, a partnership firm of a small jewelry shop, but a partnership deed had a arbitration agreement, and a dispute which had come to the court was on inventory and some small amount of rupees 5 lakhs. So that is the kind of arbitration movement we have. The peculiarity of our arbitration clauses, when we are talking in the context of Section 7 and following the other provisions of 11, which is my subject, we don't have a standard form of arbitration contract. Now, this is very crucial. Why do we feel that we have so many judgments, even judgments going to the Constitution bench on interpretation of what is arbitration agreement? I don't think that any jurisprudence out of our country would have so many Constitution bench judgments on so many arbitration provisions. That we had 7 judges bench in SB engineering, which was on 11, that the power is the judicial power, and we have the latest 7 judges in the Arbitration Conciliation Act and the stamping provisions. So that shows that how important and how live the whole arbitration movement is in our country. Now, coming to the arbitration clauses, because it is directly relevant as far as Section 7 is concerned, the understanding of a lawyer in Delhi or a solicitor in Delhi or in Bombay or in Calcutta definitely would not be the understanding of law in regard to drafting of the arbitration clause, somebody sitting in Surat or somebody sitting in Pandharpur in Maharashtra. But nonetheless, you have an agreement at the official level that the parties have agreed to go for arbitration. Now, there the problem arises. Section 7 defines arbitration agreement. And we all know what is the arbitration agreement. But how do you draft the arbitration clause? Whether it would be an arbitration agreement so that the parties can move ahead and ask for appointment of an arbitral tribunal, the very foundation of the disputes being taken to arbitration, are issues which are day in and day out coming before the courts. You will see variety of judgments which are only on whether a particular clause is an arbitration clause or not. But the most important judgment to give a clarity, I would say, is Justice Ravindran's judgment in Jagdish Chandra versus Ramesh Chandra, where his lordship has taken into consideration as to what would be the basis for a valid arbitration agreement, whether the arbitration clause would really give the or make it clear whether the intention of the parties would exist to go for arbitration. Mere use of the words arbitration or intend to go for arbitration or may go for arbitration or a kind of resolution of disputes or adjudication, I would say, in some kind of clauses has not been recognized to be an arbitration agreement. Section 7 is very clear. In the present scenario, even exchange of WhatsApp messages, somebody writes to somebody, should we go on a WhatsApp message? Should we go for an arbitration? And the other side replying that yes, why not? It's an arbitration agreement because the provision recognizes telex, telegrams, etc., etc. But what is it? It is in writing. That is the most fundamental feature, and the provision itself is very clear. It has to be in writing. But when it is by exchange, by telegrams, by telex, as the telegram nobody uses nowadays. So that has to be amended at some point of time. WhatsApp messages, emails, it is an arbitration agreement. It has to be recognized. Now, there is an interesting judgment of whether a oral agreement in a given situation would be permissible or whether it would bring about a arbitration agreement. The judgment is in Pratibha Industries in 2019, MCGM, that is Mumbai Municipal Corporation of Greater Mumbai. But if you read that judgment, I have a question. What happens in a Section 89 scenario when matters are before you and the counsel would get up both the sides and they would say that yes, the parties are here before the court. We have taken instructions and please record our agreement. In the order of the court, we want to go for arbitration. Now, this is something which is outside Section 7, but nonetheless, because it is recognized under Section 89 and the court is entitled and empowered and has authority to record such a consensus, passes an order in the presence of the lawyer, it has been held to be a valid arbitration. Nobody can back out because it is an order of the court. 89 permits the court to take recourse to these kind of ADRs. Now, coming to the next facet of this, and which has led to a lot of litigation, and including in the stamping issue before the Supreme Court, whether it forms part of, whether it is an independent agreement. Now you have a contract. In the contract or in an agreement, you have a clause that the parties agree to refer the disputes arising under this agreement to arbitration. Consistent view, the judgment in Firm Ashok, and actually the statutory recognition itself is in the provisions of Section 16. If you please see Section 16, the recognition itself would be there. I'll just read out that particular clause A. An arbitration clause which forms part of a contract shall be treated as an agreement independent of other terms of the contract. This is what Section 16 is, so it is always independent. Now this was in fact elaborated and an appropriate light was thrown by the Supreme Court in 2004 in Firm Ashok Traders, where the Supreme Court held that the arbitration clause is separable from the other clauses of the partnership deed and the arbitration clause would constitute an agreement by itself. Now this was reaffirmed by Justice Ravindran in SMST states, and thereafter the last judgment and a very recent judgment of 2021 which ultimately led to the recent 7 judges bench judgment is NN Global Mercantile Private Limited, in which it was recognized to be an independent agreement. Now there is some problem over there. What happened was that when this position was very clear, from Bombay, a dispute reached the Supreme Court on appointment of an arbitral tribunal That was in the case of Garware wall ropes, where a judgment was rendered by the Supreme Court, which in fact possibly diluted and did not accept the position which was there in the earlier judgment in firm Ashoka, but to some extent recognize in SMST states. Now, SMST states was a judgment of Justice Ravindran, which arose out of an order passed by the Chief Justice at the Guwahati High Court, refusing to appoint an arbitral tribunal. Now, why? On the ground that the agreement in which the arbitration clause lay was not adequately stamped. So the Guwahati High Court refused to appoint an arbitral tribunal, which was carried to the Supreme Court. And in that judgment, the principles of law were laid down by Justice Ravindran that yes, in fact, it is necessary that the agreement to be made admissible in evidence of which the arbitration clause is an integral part of it needs to be stamped. Otherwise, it cannot be recognized. Now, following this judgment, different high courts had taken different views. Even before the Bombay High Court, there were two distinct views which were taken. One was in Universal Enterprises, the other was in Gautam Landscape, and the matter was referred to a full bench of the Bombay High Court. The full bench considered this issue of stamping of the documents not only from the perspective of Section 9, but also in the context of Section 11. Now, SMST states was a judgment under Section 11. Now, please see, this is very crucial. Now, if you are going to apply this particular non-stamping or inadequate stamping and the agreement itself not being admissible and ought not to be considered for the purpose of appointment of an arbitrator, number one, and even for the purpose of interim measures under Section 9, it was a very, very crucial issue. Then you have a situation that you have an arbitration agreement, you are precluded from filing a suit, you go and file a Section 9 petition for interim measures, and it would not be entertained, you are remediless. So this is what was considered by the Bombay High Court in Gautam Landscape, the full bench judgment. And it was held that this 11 business, this non-stamping or insufficient stamping ought not to preclude the judge, the court from appointing an arbitrator under Section 11. Same principle was recognized for Section 9. So the judgment was delivered, say, on a Tuesday. The judgment QA Section 11 survived only for 2 days. And you ask me why. In 2 days, this issue was actually coming up before the Supreme Court. In fact, that judgment was kept for pronouncement by the Supreme Court in Garware wall ropes. And before the judgment could be pronounced, the full bench judgment of the Bombay High Court was brought to the notice of the Supreme Court. And without there being an appeal, I am speaking as a student of law, not as a judge. Without there being an appeal, there is one passage you will find that it is brought to our notice that so and so judgment is delivered, and possibly because it is contrary to the view which the court is taking, it is not a good law. So it survived only for 2 days. But 9 was not touched. The 9 issue came independently before the Supreme Court, and possibly they accepted the Bombay High Court view that 9 has to go on, that stamping objection cannot come for 9. So this was the scenario on this stamping, and ultimately Garware wall ropes itself fell for reconsideration in NN Global. A 3 judges bench could not, though Garware wall ropes was 2 judges bench, 3 judges bench could not take a view on the matter because already in Vidya Drolia, there was a implied acceptance of what Garware wall ropes said. So it was referred to a larger bench of 5 judges. 5 judges accepted what was laid down in Garware Wallroofs, and it was referred to a 7 judges bench, and ultimately the law is now settled. That the stamping, and in fact, affirmed the full bench view of the Bombay High Court. That ultimately what is stamping? Stamping is a physical measure. It is for the purpose of revenue of the state. It can't be, that is what the Supreme Court has said. It can't be an objection that you don't appoint an arbitral tribunal and the whole arbitration should take a back seat. Would not be the correct position in law. The arbitration has to go on. Arbitrator has to be appointed. Section 9 petitions, despite the agreement being defective on the stamping, the arbitration has to go on.
I think,
Now take it.
sorry, I'm interrupting, but we are running.
just to-
Just if you'll complete it,
Yeah,
we'll come back to you for 19.
For 11.
No.
For 11.
For,
I have to go
for
11.
19. 11 you are addressing, insufficiently stamped. Go ahead. Go ahead.
Yes. So, I just lost the link.
I'm sorry, my brother has lost the link thanks to me. I will remind him that he was talking of insufficiently stamped. And that the finances that go to revenue
It is
cannot be a basis for taking the clause to be irrelevant.
Correct.
The clause sustains,
Correct.
is what brother was saying.
that was the issue.
Yes.
Now, if you see the current position, all those arbitrations which were in fact not going ahead, now the law is settled on these issues. Now coming to this short, I'll conclude on 11 also, because that is again my topic. Now this, what I said on the stamping issue has relevance in section 11, because it is relevant for both it is interlinked. Section 11. Now this judgment which possibly had some effect on the arbitration movement was subject matter of consideration before the Law Commission. In the 246 report of the Law Commission, 2 decisions, basically a decision of the Supreme Court in not only in SMST states which broadened the whole parameters, but also a decision in National Insurance Company versus Bhogra Polyfab were subject matter of discussion. The Law Commission made recommendations, and why it is crucial is that what would be the parameters and the contours of adjudication under section 11 was concerning the whole efficacy, the actual working of the arbitral movement insofar as our country is concerned. Now, Bhogra Polyfab, in 2 minutes I will tell you, was a case where there was a accord and satisfaction. There were floods in Bombay. He lost all materials, he lost machinery, etc., etc. He made a claim, and he made a claim of, say, about 9 crores of rupees, to be more precise. He was asked by the insurance company that please come and settle the claim at 3 crores. So he was in economic problem. There was need of finance to workers to be paid, etc., etc. So he signed an undertaking with the insurance company, and he said that yes, please give it to me because I am really bleeding. So he accepted 3 crores of rupees. And the day he accepted, it was on a undertaking, on a stamp paper, on all letters being received by the insurance company that this is full accord and satisfaction, no claim whatsoever, thank you. But the next day, he made a complaint to the IDRA, Insurance Development Regulatory Authority, to say that this is not proper. This was a case of economic duress, and invoked arbitration agreement. Approached the Bombay High Court. Bombay High Court initially felt that it's a case of accord and satisfaction, but nonetheless the matter was decided. It is the judgment of Justice Sundara Kumar, and appointed an arbitrator. Matter went to the Supreme Court. where all these tests under 11 are laid down. That what can be the parameters of adjudication insofar as the Section 11 proceedings are concerned, where relation between the parties, existence of an arbitration agreement, whether the claim, really a claim survives, a live claim survives, all those parameters were applied. And possibly making it a limitation, everything. Possibly giving a color that it would be some kind of mini trial at the stage of 11. And this prompted the Law Commission to say in its report that this actually such a approach may not be a approach pro arbitration. And that is how Section 11 came to be amended and subsection 6A was incorporated. Only existence of an arbitration agreement. No less, no more. That is what the Supreme Court in a recent 2025 decision says. Only the existence is to be seen. But for appointment of an arbitral tribunal, the other issues, and because of constraints of time, I am not taking it, it's a huge subject. It can be discussed more. That even issues of limitation can be now gone into. There are judgments which I'll give the references to you. That whether it is a dead wood. Example, 1975 or say 1985, there was a claim made. There was a invocation. And he does nothing. And again he writes a letter, say in 2024, and he receives a reply, sorry, we are not going. Would it give a cause of action? No, it's a dead wood. The Supreme Court said it's an MTNL. The BSNL is a judgment. So in this kind of situations, the court says that you can't burden the other side by an unwarranted exercise of litigation. Section 11 court would look into only the limitation. When was it invoked? Whether it satisfies the limitation under 137, Article 137 of the Limitation Act, and proceed to appoint an arbitrator.
Right.
So thank you so much. I would not.
Thank you, brother. We are now at this moment confining ourselves to section 7 and 11 and keeping aside 19 because brother has run out of time. We are running it on a timeline.
Do stop.
The second topic, equality principle in arbitration. Brother Supaya will address it under section 18. What are the questions? The questions posed are the following, and so that we don't waste time on the questions one after the other. On 18, the questions that we have decided to focus on are, what are the core principles enshrined in section 18? What are the consequences of violating section 18 and the remedy? Do the provisions of the CPC and the Evidence Act apply to the arbitral tribunal? Whether principles of waiver is applicable under section 18, and lastly, which provisions of the Arbitration Act interject with section 18? These are the questions of 18. I'll first ask brother to address us on 18. 20, I will verbalize after he's finished it in this 10 minutes. Thank you, brother. Please go ahead. You want to take?
Thank you so much. Thank you so much. I got the hint I will be succinct. We'll try to finish off within 10 minutes. Now, section 18, as you know, all of you, it's equal treatment of parties to the parties and to give a full opportunity to present their case. So that you will be doing every day when you come across in all your proceedings. But in the context of the Arbitration Act, section 18, it's the thread of section 18 runs to the fabric of the arbitration proceedings. It is the provision which enables party autonomy, selection of arbitrator. It interjects with other sections. The ineligibility of the arbitrator as under section 12, subsection 5, 7th schedule. Section 19, which provides for rules of procedure. There also section 18 plays the roles. 24, hearing and written proceedings. Section 25, default of the party in ex parte. This is where the ex parte proceedings emanates from. So the remedy of violation of the provisions of section 18, as you know,
I wanted to
will render the award vulnerable to challenge under section 34 on limited grounds that is already discussed by the panelist. So for the judgment, there's a judgment on this issue with the Supreme Court has set aside the award only on this ground that full opportunity was not given to the parties under section 18. Now, section 18, that is what constitutes a fundamental principle to the arbitral proceedings, and any violation thereof will render the award bad on limited grounds that's discussed by the earlier panels. So it's a very limited provisions, and it's only one liner, but it's very, very effective in controlling the proceedings, controlling the arbitrator's eligibility. This is what it can be confined to.
Absolutely, brother. We'll next touch upon section 20. There are a host of questions that arise in section 20 with that deals with place of arbitration. We had mentioned when we started with whether the words place, venue, seat are interchangeable or not. Brother Suppaiah will address us on that. The questions are almost running into weight. We've also factored in questions by the judicial, by the members of from the audience that have been received by us. Several questions. So, brother, we'll open the next 10 minutes only to section 20.
Thank you so much. See, the section 20, it's confined to the seat, place, venue of the proceedings. Now, all these expressions don't find the definition in the Arbitration Act. The Supreme Court, in case of Vedanta 2020, has held like this. I may quote: the seat, legal seat must not be confused with a geographical convenient venue chosen to conduct some of the hearings in the arbitration. The courts at the seat of arbitration are referred to as the courts which exercise supervisory or primary jurisdiction over the award. The laws under which the award was made, used in Article 5 into bracket 1 of New York Convention, is mirrored in section 48 into bracket 1 into bracket E that relates to enforcement of foreign award of the Indian Arbitration Act. Now, this was further, the landmark judgment on this would be BGS Soma, which was further considered by the Supreme Court. And I may quote a paragraph from that. Turning to section 20 of the Act, subsection 1 in clear terms states that the parties can agree on the place of arbitration. The word free has been used to emphasize the autonomy and flexibility that the parties enjoy to agree on a place of arbitration, which is unrestricted and need not be confined to the place where the subject matter of the suit is situated. Subsection 1 to section 20 gives primacy to the agreement of the parties by which they are entitled to fix and specify the seat of arbitration, which then, by operation of law, determines the jurisdictional code that will, in the said case, exercise territorial jurisdiction. Subsection 2 comes into the picture only when the parties have not agreed on the place of arbitration as the seat. Section 20 into bracket 2 also applies when the seat as mentioned in the agreement is only a convenient venue. In terms of subsection 2 of section 20, the arbitral tribunal determines the place of arbitration. Then comes subsection 3 of section 20 of the Act, enables the arbitral tribunal, unless the parties have agreed to the contrary, to meet any place, to conduct hearing at a place of convenience in matters such as consultation among its members, for the recording of witnesses, experts or hearing parties, inspection of documents, goods or property. So overall, the section 20, there would be some place determined in the agreement, which would be a seat. However, there would be subsequent proceedings. During the arbitration proceeding, their parties may inspect documents, hear on other places, those can be termed as a venue. But the actual seat would be a seat which determines the jurisdiction of and it's confined to the courts on which the parties submit to it. So there is a lot of conundrum on the seat, venue, and place. Ultimately, the Supreme Court has, in recent judgment in Arif Azim, has clarified the parameters of section. May I quote that? The moment seat is determined, it would be akin to an exclusive jurisdiction clause, whereby only the jurisdictional courts of that seat alone will have the jurisdiction to regulate the arbitral proceedings. The notional doctrine of concurrent jurisdiction has been expressly rejected and overruled by this court in subsequent decision. Now, there was a closest connection test, which is not watered down to some extent in this judgment. I may quote the paragraph. The closest connection test for determining the seat of arbitration by identifying the law with which the agreement to arbitrate has its closest and most real connection is no longer a viable criterion for determination of the seat or status of arbitration in view of the Shashua principle. You may be aware of the Shashua principle. I think. Oh, yes. The seat of arbitration cannot be determined by formulaic and unpredictable application of choice of laws, rules based on abstract connecting factors to the underlying contract. Even if the law governing the contract has been expressly stipulated, it does not mean that law governing the arbitration agreement and by extension of seat of arbitration will be the same as the lex contract, that is law of contract. The Supreme Court in para 9 or clarified to this closest connection test, and it is held. We do not for a moment say that the closest connection test has no application whatsoever where there is no express or implied designation of a place of arbitration in the agreement, either in the form of venue or curial law. There the closest connection test may be more suitable for determining the seat of arbitration. So these are the fundamentals which the Supreme Court has clarified.
Yes.
So far as section 20 is concerned, we will see that the participants may raise some queries to us.
Yes, after we
After
have
the
two
completion of
first we
session.
completed.
Yes. Yes, very important.
Yes, absolutely.
Yes,
Matter
absolutely.
is a challenge laid to,
On the jurisdictional
Jurisdiction part.
and that goes to the root of the
That's the
matter.
root of the matter.
So
yes.
that's imperative that it be understood and implied in the correct sense. Otherwise, the whole process can turn sour.
Yes.
So it is no doubt it is very important for you as judges to consider this aspect and for lawyers to argue on this aspect. Coming to Brother Sabyasachi Bhattacharya, the topic number 3, power to refer parties to arbitration under 8. Very important. Such applications are thrown up very often. And what would be the scope of inquiry of a court? What are the parameters that the court must remain within when Section 8 is quoted? That is what Brother is going to throw light on.
Wish everybody a very good afternoon, and taking a cue from Justice Kohli, for the sake of brevity, I would not be thanking the Chief Justice and the Gujarat Judicial Academy for this wonderful opportunity to meet the district judges and the lawyers where the case starts. So I won't be doing that, and I'll be studying on the topics. The topic is Section 8. Section 8 is in a separate niche than the other provisions in the 1996 Act, where principal civil courts of original jurisdiction have been empowered not as courts as such, but as authorities under the statute. The statute says court means this, principal civil court of original jurisdiction. That's why all the other sections designate the principal civil court as authorities under the statute to be so. But Section 8, in a Section 8 scenario, you are the civil court which is in season of a regular civil suit, and under Section 9 of the Civil Procedure Code, it is the civil courts which are in season and which can try all suits of civil nature, unless there is an express or implied bar. The question which arises is,
whether Section 8 or within the four corners of the 96 Act, there is any bar to the civil court exercising jurisdiction. And the resounding answer is no. There is no bar in a civil court exercising jurisdiction, despite there being a clear arbitration clause between the parties. This is also on the party autonomy. Because if the parties have autonomy to choose an arbitrator as their arbiter, the parties also have equal autonomy, one party to file a suit as a plaintiff and the defendant to waive the right under Section 8. So that is also a part of party autonomy. Therefore, if a suit is filed, there is an arbitration clause. As a matter of course, you don't reject the plaint, return the plaint, or do anything. So what do we do? A question has come from the judiciary apparently that if there is nobody asks, then what do we do? Section 89 of the CPC complements Section 8. So Section 89 says if there is a scope of settlement, if there are elements of settlement applicable to which parties are agreeable, then yes, send it to arbitration, mediation, lok adalat, or to some other mediation. But then this there is a judgment Afcon's infrastructure 2010-8 SCC 24, which says that Section 89 exercise is mandatory to ascertain whether there is any element of settlement. But reference is not mandatory. If there is no element, parties don't agree, don't. So this is the jurisdiction under Section 8 coupled with Section 89. If there is an application, unless there is an application, don't send, don't return, don't reject. And Section 89 exercise has to be done. If not possible, leave it at that. So the next point is now there is one judgment of a learned single judge of the Madras High Court, Justice P.T. Asha, 2019 SCC Online, which says the same thing. I'm not repeating. Cannot suo motu reject. Now the next question is, when can a Section 8 application be filed? Section 8 is very clear. Not later than the first statement on the substance of the dispute. Everybody here knows that a written statement contains the substance of the dispute. There is no dispute on that dispute. But where there is a dispute, now it has been widened now. The first statement is not confined only to the written statement. It has been held in Booz Allen. Since this is a dry state, you can remember by the second name also, Allen. So Booz Allen is very specific on this, and Booz Allen takes into account Rashtriya Ispat Nigam and previous judgments. And Booz Allen says, no, not only written statement, but there is an application. If there is an application which submits to the jurisdiction of the court, that is a statement of the substance in the sense that I want to submit to the jurisdiction. One example, application for extension of time to file a written statement. When I submit to the civil court, I say I will file a written statement before you, and therefore this is not a Section 8 scenario. So in such a case, it's a statement on the substance of the dispute. You say I refer this dispute to the civil court and no Section 8 reference. One interesting judgment of the Delhi High Court, Assam Petroleum, where it has said that if the party fails to file the Section 8 application within the time available for filing the first defense, that is within the statutory time limit of filing written statements, say, if you fail that timeline, then Section 8 won't be allowed. It is not there in Section 8. But what is the reasoning behind this? Because if you don't file the written statement in time, in the suit you lose a defense. So it will proceed ex parte. You cannot rectify that situation by failing that time and then taking out a Section 8 and saying that let me go to the arbitrator where I have a new lease of life by filing a written defense, statement of defense. So that is the premise. So this is on when Section 8 application should be filed. When should it be heard out? Whether before or after interlocutory applications? I say, in my opinion, before any interlocutory application, first you have to hear out Section 8. Because the moment you are granting injunction when there is a pending Section 8, you are intruding into the Section 9 jurisdiction of the court under the Arbitration Act and also Section 17 of the arbitrator, if it was to be referred. So therefore, before any other application, please decide the Section 8. That is my limited viewpoint. Third question, most important question. What is the scope? Can a suit be referred to arbitration if some of the disputes or the parties don't tally, the parties in the suit and the arbitration agreement parties? What happens then? Scope of decision is when you get a Section 8 application threefold. One, whether the dispute and the parties are covered by the arbitration agreement. Two, whether there is a prima facie valid arbitration agreement, prima facie, italics, prima facie valid arbitration agreement. And three, whether the subject matter is arbitrable. I'll touch one by one. First, whether parties and disputes fall within the scope of arbitration agreement, the parties in the suit. Regarding parties, there was judgment Sukanya Holdings. Sukanya Holdings 2003, 5 SCC 531. That was the landmark judgment then. But that was very strict. It said parties and subject matter has to tally the suit between the suit and the arbitration agreement. Regarding parties, there has been much dilution. I'll come to that immediately hereafter. But regarding this subject matter, Sukanya Holdings held that bifurcation of the subject matter or parties is not permissible. Part of it is covered by the arbitration agreement, part is not. Some of the parties are, some are not. We cannot bifurcate and send it to partly to arbitration. I have a take on this with utmost respect to the judgment of the Supreme Court. When I take up a Section 8 application, I am still a civil court. A civil court under Order 2 Rule 6 has the power, if there is a misjoinder of parties, the exact language is joinder of causes of action in one suit, may embarrass or delay trial or is otherwise inconvenient. Court may order separate trials or make such order as may be expedient in the interests of justice. Therefore, under Order 2 Rule 6, court has the power to segregate causes of action if they can be separable. If that be so, why can't I as a civil court do that and say that this part can go to arbitration, this part cannot, if it is segregable? If they are intertwined, I cannot. Similarly, regarding parties, civil court has the power. When I take up the Section 8, I am still a civil court. Order 1 Rule 2, similar to Order 2 Rule 6 regarding joinder of plaintiffs. If a party is artificially joined or a cause of action or relief is artificially joined to a suit, which is otherwise the crux of the relief is covered by the arbitration agreement, just to go out of the ambit of arbitration. What do? I think personally that we have the power under Order 2 Rule 6 and Order 1 Rule 2 to segregate and to separate trials, one before the civil court, and take up the Section 8, and we can refer it to the arbitration. But this is a debatable topic. I'll leave it to the discussion before the forum. Regarding signatories, parties, yes, initially Sukanya Holdings held that yes, parties have to be the same, but no. Chloro controls came in 2013. 2013-1 SCC 641. Chloro controls brought in a new dimension. Anybody claiming through or under a party can also be a party within the conception of the Arbitration Act. And what has to be done? Mutual intention of the parties on the basis of a composite nature of transactions, commonality of subject matter, and direct relationship between the parties, signatories and the non-signatories has to be there. This was brought in by Chloro Controls first. If that is so, he will be construed to be a party and it can be sent to arbitration, will be considered to be a party to the arbitration. Chloro Controls principle was brought in by UF statute by the 2016 amendment with retrospective effect from 23rd of October 2015. That was made a part of Section 8. Now Section 8 reads that any party or anyone claiming through or under a party can apply under Section 8. That has been widened. But definition of party in Section 2(1)H still remains parties to the arbitration agreement. How do we reconcile? Reconciliation was done in Cox and Kings by the Supreme Court. Cox and Kings 2-judge bench raised certain questions. 5-judge bench in Cox and Kings 2024 4 SCC answered the questions. Two important aspects were brought in. It was said that parties under Section 2(1)H read with Section 7, as Justice Kulkarni rightly pointed out, that it's very wide open. I mean, even in a statement of defense, if I don't deny your assertion of there being an arbitration agreement, without a written agreement of arbitration, that writing becomes an arbitration agreement. Telex messages exchanged, no writing, no single agreement, but that becomes an arbitration agreement. Therefore, strictly speaking, one need not have one agreement where all the parties sign. So this Cox and Kings said parties 2(1)H has to be read with Section 7, and parties include signatories and non-signatories. When does it happen? Group of companies doctrine was brought in. What is a group of company? Any company which is a part of the same corporate structure, and part of the, not only that, the conduct of the signatories and non-signatories to the arbitration agreement has to be such that a common intention to make the non-signatories party to the arbitration agreement has to be borne out. If that is there, then non-signatories are construed to be parties to the arbitration agreement, and they can be brought within the fold of this. Therefore, Sukanya Holdings is being widened. First, it was held that, yes, parties claiming through, then, no, not even parties claiming through. Parties where there is a group of company and they have a common intention to join in arbitration, they can be brought. So, this is the current position regarding parties. Section 8, two more judgments. Sorry to bother you with so many judgments. One is Magic Eye Developments 2023 8 SCC 50, page 50. What does it say? A section 8 or a section 11 court, which are threshold courts, if you may say so, those have to decide at the threshold the validity, the existence of a valid arbitration agreement. You cannot put that to the arbitrator to decide. Prima facie, you have to decide whether there is a valid arbitration agreement. In Rashid Raza versus Sadaf Akhtar 2019 8 SCC, a distinction was brought between a simple allegation of fraud and a serious allegation of fraud. What is a simple allegation of fraud? Merely fraud, fraudulent activity, which is a part of the dispute. Serious allegation of fraud is that which hits at the very root of the arbitration agreement, the agreement which contains the arbitration clause. As opposed to section 16, as Justice Kulkarni pointed out, this is an aberration. It says that if there is a fraud which vitiates the entire agreement containing that arbitration clause, for that purpose, the arbitration agreement does not exist because it hits at the root of the validity, existence of a valid arbitration agreement. So, the Section 8 court decides it. It's a serious question of fraud. And also it hits the public domain and not merely touching the rights of the parties. Because serious fraud amounts to criminal jurisprudence, which is debarred. I mean, from arbitration being decided by arbitration. So if it's a question of serious fraud or something vitiating the arbitration agreement itself, you have to decide the validity of that arbitration and the existence at the threshold. Section 8 stage, this is one of the considerations. Lastly, I'll be saying arbitrability of subject matter is the third thing. Apart from whether the parties and the disputes are covered by the agreement. Secondly, this valid existence of an arbitration agreement. Third question which you have to see is arbitrability of the subject matter. One single judgment, there are various judgments touching various aspects of this matter.
If you could just give the essence of.
Yes. I'll say Vidyadrulia 2021 2 SCC 1 that charts the what are the non-arbitrable things, and I'll just be specifying those and stopping. Now, first is where the cause of action and subject matter relates to actions in rem. Simple example, probate, even matrimonial, in fact, admiralty jurisdiction, insolvency. These are all judgments in rem. Judgment in rem cannot be passed in a private tribunal. So that's the principle on which those are not arbitrable. Second, if it affects, is somewhat like in rem, affects third-party rights having erga omnes effect. It requires a centralized adjudication, and mutual adjudication between a chosen forum cannot be done. Affects third-party rights. Third, relates to inalienable sovereign and public interest functions of the state. Those cannot be brought within the confines of arbitration. This broadly includes criminal matters where the crime is committed against the state also. So, inalienable sovereign and public interest functions of the state, those cannot be done by an arbitrator, chosen party. Lastly, express or necessary implication. By express or necessary implication, it's non-arbitrable as per some mandatory statute. One example, Supreme Court has held in several judgments, rent control statutes, designate particular forum, particular procedure. In those designated cases, it's the mandate of the statute that makes the dispute non-arbitrable before a private forum. These four things, in rem, third-party rights, inalienable sovereign public interest functions of state, and non-arbitrable for mandatory statutes. These four are the exceptions. These four are the exceptions where subject matter is non-arbitrable.
Thanks, brother. That was very precise. Justice, Chief Justice Sunita Agarwal had a question.
Which you can note and
Yes.
answer it later. Like you have deliberated on the segregation
Yes.
of dispute and segregation of suit, in fact,
Right.
saying that some part of the suit can be segregated.
Yes.
And if it is segregated, the civil court can exercise jurisdiction. And for the rest, the civil court will be able to send it for arbitration.
Yes.
So my query is for the sake of clarity, because they are not speaking, so I'm speaking on their behalf. So, arbitration clause,
Yes.
generally when we read, it says that dispute arising out of and in relation to the agreement between the parties.
Contractual or legal relationship,
Huh.
which
So
is very important.
normally, when we read arbitration
Defined legal.
clause, it says that the dispute arising out of or in relation to the agreement between the parties will be resolved by way of the process of arbitration. That sometimes they mention
Yes.
Arbitration Act or not. But then these are two areas where I have this query: arising out of and in relation to. So arising out of is, you can confine it, but in relation to is a wider term.
Yes.
Correct. So then some clarity is needed for them.
Absolutely.
You can answer it.
Brother, you'll
Yes.
take a note of it and we will answer it
Yes.
after the, after
As-
the session.
Because I'm dealing with one of
Very
the matter under section 8, where there was a relief that there was a partnership agreement, there was a partnership deed, and then there was a suit where a relief is sought that I should be declared a proprietor of this firm.
I would touch that only. That is the
So
specific
please-
problem in my mind.
Please that.
Let's take a note of it and go to thank you. The Chief Justice has vocalized
And
this
This
question.
question is definitely on their behalf.
Yes, on behalf
Absolutely.
of all of, many of you. And we hope there are other questions also that you have in your mind and we have ample time to answer it. And that is why the speed with which we are trying to progress and go to the next topic, topic number 4. Principles of competence under section 16. Mr. Balbir Singh, senior advocate, is going to address us on scope of section 16 and at what stage can it be filed, an application under 16. Can jurisdiction of the tribunal be questioned by parties under section 16 after having participated in or after having consented to appointment of the arbitrator? And 3, what is the remedy against orders passed under section 16? Mr. Balbir Singh.
Thank you, Justice Kohli.
Thank you.
I think 3 judges have taken a position. I would say that the presentation from a judge's standpoint, let me give a position from a lawyer's standpoint. So I think this is important because for lawyers, section 16 is bread and butter. And why I say bread and butter, it goes with section 8, it goes with section 9, and it goes with section 34 and obviously 11 also. So the section 16 jurisdiction issue can be raised at the 8th stage, can be at a 9th stage. So it is pre-arbitration, during arbitration, after arbitration in section 34. The 16 is the bread and butter and the young lawyers are there and I can tell them that this is quite a fruitful tool which is there for them. But coming to serious note, I think the competence principle broadly is in line with the Act and the principle based on which the arbitration as an alternate dispute resolution mechanism was thought of, created. The objective never was that the dispute should go to the court and court should look into the dispute, whether it's from the section 7 standpoint is the definition of agreement, whether it's from 8, 9 or 11. 11, 9 and 8 were the tools that on the initial stage, how do we determine that A, there is existence of agreement. It has struggled a lot for a very long time, but 2015 agreement brought it to a position, amendment brought to a position saying that the court is to see the existence of agreement. Now, as Justice Bhattacharya mentioned that, what do you mean by the existence of agreement? Do you check the valid agreement? Do you check the beyond the validity? Or look at the agreement, if there is an agreement which is satisfying the requirement of section 7, stop at that. Now, this is one aspect which takes a lot of time before multiple courts and the lawyers take the argument of saying a not stamped, not valid agreement, goes to the constitution bench takes up a position, 7 judges finally say that no, we just need to look into it, and especially after 5 judges saying no, not stamped is a void, and therefore it goes further to 7. So what I'm saying is that these small matters take to such a level and where the arbitration get derailed, hearing after hearing goes on, and the matter doesn't go outside the courts and never reaches the table of arbitrator or tribunal. Section 16 is precisely for that purpose, that for all purposes, the court should not be brought into so far as to check the jurisdiction of its own has been given in the hands of the tribunal or the arbitrator to look into their own jurisdiction. And the language of the law is very, very clear if you look at closely. And that over a period of time, we have seen multiple judgments coloring it. The subsection 1 itself is so clear, say own jurisdiction. So first principle is until unless it is an event of a fraud, not arbitrable because of tenancy, admiralty, any statutory restraint which is there. Once there is an agreement at section 11 stage, I don't think beyond anything is required to be seen, which has after 7 judges in the stamping judgment, which has made very clear. We don't need to look into that part. Even reconciling the position with Vijay Darulia, the issue was only whether the agreement is to be seen or validity of the agreement is to be seen. I can understand because on a first principle prima facie basis, a valid agreement is an agreement which is to be seen. And if we see the section 7, because there the word used is contractual or otherwise. So therefore the first examination I agree, but beyond that examination, I don't think section 16 gives that authority to any other thing, because otherwise the whole purpose will get defeated. So the first word is it's may rule on its own jurisdiction. Thereafter the word starts includes. So it is such an extensive power which is given under section 16, the tribunal should comment or owe its own jurisdiction. What further is includes, and then it comes to the existence and validity of agreement, which means that if in the ordinary circumstances at section 11 stage this to be looked into and section 16 is pressed, it is very clear that the includes start at a second stage where the existence and validity can also be seen, and not necessarily in all circumstances that at the 11th stage this is to be examined. Third thing is says that why the word had been said. It's a legislative recognition which has been given for a purpose in 2 parts, A and B. A says that the contract and agreements are 2 separate things. That's a legislative recognition which has been given. That is to be kept in mind. That I don't think we need to break our heads on this to say that whether the agreements are 2 agreements, 1 agreement. It's a legislative recognition which has been given in part A, and that is good enough to make it very clear. For that purpose, it is to be seen. And second part is making it further clear that if the underlying contract is null and void, the arbitration of agreement is a standalone independent argument. That's not also to be seen. That's the job of the arbitrator. And all these are issues which can be examined by the tribunal itself. So it's a very formidable power which has been given, testing its own jurisdiction, beside testing it on the existence and validity of agreement. That makes the first part very clear. And if we see as judges, I think all of you must have seen that these aspects, it take multiple days and days of hearing that we examine these aspects. But I think after stamping judgment, there is some conclusion, my understanding on the subsection 1 that can be taken care of. The subsection 2 makes it very clear. The difference between 3 is that no jurisdiction is exceeding the authority. These 2 are completely different in landscapes which are there. If it is no jurisdiction, that's a complete different test is to be applied. And the first stage to be raised is that the statement of defense is to be filed is the timeline when you to see. And it is important at that stage, at 16 stage is to be seen, whether it's the exceeding authority allegation is there or no jurisdiction allegation there. These are 2 different classes of objections which are raised on multiple occasions. On the first part, it has been said that the statement of defense, I'm not coming to subsection 4 because the power of condonation has been given to the arbitrator too in a certain circumstances, but otherwise the law is very clear. The stage 1 is if the statement of defense is the stage, the objection is to be raised on no jurisdiction. And if you closely compare it with 3, as soon as possible, the word is as soon as, because that exceeds the jurisdiction, because the test is going to be extremely high in that case, because you agree there is a jurisdiction of the tribunal, but that authority has been exceeded too. Therefore, as soon as the liberty is far higher in subsection 3 than subsection 2. Subsection 2 is very clear that in this aspect, please look at the first stage and close it. Subsection 3 says exceeding the authority as soon as possible, and therefore that as soon as possible is a fact dependent, a fact of subjects of each case you need to examine at that stage. Please look into it and examine. whether all these issues are raised in 8 stage, 9 stage, 11 stage or 34 stage. 34 stage, why I'm saying so is the argument of waiver is taken very obviously that it has not been raised at this stage or that stage, therefore it's been waived. So there are divergent high courts on this, whether if it has not been taken at 2 stage or 3 stage, subsection 2 or subsection 3 stage, is the waiver applies. That's again a fact dependent case. If it goes to the root of the matter, like the recently in 2025, the issue was that the arbitral tribunal was not the relevant tribunal under 1996 Act, but the state authority MSME tribunal was the statutory tribunal, that's the right tribunal. Whether that amounts to waiver or not, Supreme Court said, no, it's not a waiver that's to be part because it's a jurisdictional, go to the fundamental root of the matter. It can be patent illegality in 34, that stage can be examined on that part. So this traversed through and through that the difference between 2 and 3 should be recognized for judicial officers, that what are we dealing with at any stage we are dealing. That's, to my mind, is a very important thing which is there. And 3 is as soon as why it has been specifically given, the extensive rope has been given to say because you are testing a valid tribunal constituted, looking into exceeding of authority happening or not, that's the differentiation between there. 4 says in subsection 2 and 3, if the delay can be explained, this can be given. Courts have said that so far as examining, the tribunal examining the delay to be condoned or not by using subsection 4, the test in 2 and test in 3 are different. That's what's been there, and differentiation depends on case to case basis. Now, what happens if an application is filed or objection is raised? Ordinarily, Justice Kohli clarified in the beginning, that if the objection is rejected, the arbitration should go on. It doesn't mean that the argument of no jurisdiction or no exceeding authority is not available, but somebody need to wait till 34. Raise the 34, that can be ground of waiver, that can be ground of patent illegality, that can be ground of policy. Any ground can be raised, but that grounds can convert it to 34. Chance is a 34 stage. But 34 must go on. There is no order passed required to be passed. It is completely a discretion given to the tribunal. That tribunal can see at what stage the order is to be passed. Second, the component this can be, assuming for a minute that the tribunal agrees that yes, that I do not have authority, either by virtue of violation of subsection 2 or subsection 3, therefore pass an order, and he becomes a functus officio, passes saying that I am not competent because of any law, any authority which has been there. Then the remedy is where law is very clear that the appeal is provided under section 37. At that stage, the challenge can be mounted in 37 and that separate remedy is taken at that step. That is the construct of this. But in my understanding, as the law has been laid down, we look at Abu Zalan, NM Global, all these laws are making it very clear that the objective of this section is to be read along with when we read it with 8, 9, 11, 34 is that minimal interference of the courts is desired and most of the work which is required for resolving a dispute for the purpose of this which has been created. A confidence has been given to the tribunal and the tribunal is supposed to decide all this so that we can achieve the timelines, we can achieve the efficiency and the very purpose when the two-party autonomy says that we don't wish to go to the court, don't push them to the court. Let them decide before the tribunal and the seamless objective is achieved by virtue of section 16. That's why I say section 16 is a bread and butter. But when we look at simplistically, it's very clear that what the object is. Although the 16 will always be read with at a 8 stage, 9 stage, 11 stage and 34 stage. That's in a broad essence to my mind is a mother provision which in essence with the object of the act is provided. And the differentiation is quite clear. Stages are quite clear. The power of the tribunal to be at what stage, what to be done given.
Yes.
And then 37 has been provided.
Thanks so much. Thank you, Balbir. That was a good overview that you've given us. Topic 5, last but not the least, till we open the house to questions. Topic 5, challenging the arbitrator. We have Mr. Ritan Rai, sections 12, 13, and of course the schedules attached to it, the 5th and the 7th schedules. The questions I'm posing to him right away so that he keeps it in mind while addressing you. Under section 12, what time limits are placed on the freedom of the parties in arbitration so that the dispute is decided without any bias, fairly? Second question, when have courts stepped in to strike down arbitration clauses that seemed fine under party autonomy but threatened fairness? What does the law say on this? 3, can a party be deemed to have waived applicability of Section 12? This is as far as 12 is concerned. I'll pose the questions under 13 too, because they're intertwined, and then Ritin will handle them. Under 13, what steps are available under Section 13 to challenge an arbitrator? And how do these relate to Section 14 applications for terminating the mandate of the arbitrator? 2, power of tribunal to decide on the challenge to its own constitution. 3, procedure when the arbitrator withdraws from the arbitration or when an application under Section 13 is allowed. Lastly, remedy against rejection of application moved under Section 13. Ritin, the house is yours.
Thank you very much. Thank you. And I think I have to thank the Honorable Chief Justice and a brother and sister judge of the Gujarat High Court for affording me this opportunity to speak to all the district court judges and to be part of this panel. For me, it is a real honor. And it is a very important discussion because I think, as has been said in the session before and even now, the decision that is made at the first level of the court is a decision that is largely respected in the first appeal in Section 37 or further proceedings in the Supreme Court. I mean, there are decisions which say 37 is narrower than 34 or 9. So that decision that is taken in the first proceeding is a very critical decision. And we need to understand, therefore, the essence of the Arbitration Act before we apply any of the sections of the Arbitration Act, particularly 12, 13, and 14, which I will be speaking on. And for me, it's also a real honor to be part of this panel. I would anyway have been brief in a post-lunch session and a session or a talking time I've got, which is just before tea. I would anyway have been succinct, but I have had the experience of appearing before Justice Kohli in court, and I know that I need to be succinct even otherwise. Just before I come to Section 12, and to try and talk a little bit about the rationale of the Arbitration Act, I think one section that we must also be aware of is Section 28 of the Contract Act. Section 28 says all agreements in restraint of legal proceedings are void. Explanation 1 to Section 28 exempts arbitration agreements. That is what gives an arbitration agreement validity in a sense. So it is really the state saying that ordinarily you cannot restrain a party from going in legal proceedings. That is also Section 9, the power of all civil courts. But the explanation is what says that an arbitration agreement, if entered into, will not be invalid. And that goes to what Justice Kohli said at the very outset, that unless there are some limitations on party autonomy to appoint arbitrators, we are running a little risk that the integrity of the arbitration process is undermined. So on the one hand, there is the challenge to maintain the integrity of the arbitration process. And on the other hand is also what Justice Kohli started us off with, that you should not allow frivolous or tactical challenges. With that framework, and with the framework that I think we're all aware of, the arbitration law is fundamentally about party autonomy. We want to allow parties to frame the arbitration agreement, the arbitration processes autonomously to the extent possible. And what do we mean by autonomously? And now if we come to chapter 3 of part 1, you see these various provisions of party autonomy. So for example, Section 10, parties are free to agree on the number of arbitrators. Or Section 11.1, a person of any nationality may be an arbitrator unless otherwise agreed to by the parties. Or even 11.2, parties are free to agree on a procedure to appoint arbitrators. So that is what we mean by party autonomy. To the fullest extent possible, parties have autonomy to decide the nationality of their arbitrator, the qualifications of the arbitrator, the number of arbitrators, the procedure. But there must be some limits to how far the parties can go. And I think Justice Anjaria said this in the morning to us, that ultimately an arbitration needs to be fair to both parties. Ultimately, there has to be some concept of equity or morality in arbitration. And that is really Section 12 of our Arbitration Act, which says fundamentally that if you are going to an arbitrator, that arbitrator must be independent, that arbitrator must be impartial. You cannot have an arbitration which the state will recognize, the award the state will recognize, unless you have some checks, some ability to find that the arbitrator who has been chosen by the parties is indeed independent and impartial. And that is codified in Section 12 of our Arbitration Act. Originally, the Act only said that in Section 12(1), and I'll read that, when a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances likely to give rise to justifiable doubts as to his independence or impartiality. So it was a broad requirement, and the arbitrator would decide himself or herself to disclose those facts which likely gave rise to justifiable doubts as to her independence or impartiality. That was found to be perhaps too broad and unguided, and so we had a set of amendments in 2015 that brought in the 5th schedule. And the section now read that the arbitrator will disclose those items with regard to the matters contained in the 5th schedule. And so the 5th schedule then guided the arbitrator as to what he or she needed to disclose. And illustratively, if I may just tell you, the 5th schedule gave a set of examples where the arbitrator's relationship with parties or counsel needed to be disclosed. So, for example, if the arbitrator was an employee, consultant, advisor, or had any other past or present business relationship with a party, that must be disclosed by the arbitrator. Or similarly, item 16, the arbitrator had a previous involvement in the case. So now the arbitrator is required to disclose upfront any of these facts which might give rise to a feeling of independence, a lack of independence, or lack of impartiality. And what happens with that disclosure? That disclosure is made upfront when the arbitrator is appointed. It's also to be made on a continuous basis. If some event develops, the arbitrator is required to disclose that during the pendency of the arbitration. It allows a party to then challenge the arbitrator if that party believes that circumstances exist that give rise to justifiable doubts as to his independence or impartiality. If that challenge is rejected, that challenge is in the first instance made to the arbitral tribunal. If it is rejected, the arbitration continues. It becomes a ground of challenge in a section 34 that is filed before your court. And that is when the 34 court can look at this issue again. There are some matters which, if an arbitrator is part of, he is simply ineligible to act as an arbitrator. That is contained in the 7th schedule, and that is drawn from a list of the International Bar Association. It's called a red list and an orange list. And so as the colors suggest, if it is a matter in the red list, which is also our 7th schedule, then an arbitrator is simply ineligible to act. And if he's ineligible to act, then automatically under section 14, his mandate terminates. You don't need to go to the arbitral tribunal first. You can directly come to the court under section 14 for a declaration that his mandate has terminated. I'll end with just one decision of the Supreme Court in HRD versus Gale, which guides us, I think, on what Justice Kohli was saying, that on the one hand, you need to uphold the integrity of the process, and on the other hand, you need to reject frivolous or tactical applications. An argument was made before the Supreme Court in a decision called HRD versus Gale, 2018 12 SCC 471, that because an arbitrator's award is so final and the grounds of challenge are so limited, the items in the 5th schedule and the 7th schedule need to be read very expansively. The court rejected that argument in paragraph 16, where it said that you need to give plain effect to these items in these schedules. You need not be expansive, you need not be hyper-technical, but what you must have your mind to is that the parties must be before an arbitrator who is impartial and independent. So that's the guidance the Supreme Court gave us in HRD versus Gale. I don't have enough time, but it's also a decision which explains the challenges made in that case to the two arbitrators were on the grounds of item 1, namely that one of the arbitrators had given an opinion to one of the parties in the past. The court said this is not a business relationship. This doesn't disqualify the arbitrator. And similarly, one other arbitrator in that case had acted as an arbitrator in a previous dispute between the same parties. The court looked at item 16 and said that's a previous case, that is not involvement in this case within the meaning of item 16.
So Ritin, maybe just to activate our audience, they've had a very long stint of our speaking to and they're listening to us. And fortunately, it's 3:20 that we started and it's 4:45 that we finished the session. We'll give a random example so that we can elicit a response on the questions that Ritin just discussed as to whether the eligibility of an arbitrator should be considered at what stage, and would the arbitrator in a given circumstance take, for example, if the arbitrator has no business dealings with a party, but the arbitrator's husband happens to be the landlord of in respect of a property which is taken on rent by the sister concern of a company appearing before the arbitrator. Would the House say that the arbitrator is disqualified and should be ruled out from the arbitration? If it's a yes, please raise your hands. Okay, and would you say it should not be ruled out? If you say it should not be ruled out, how many think that the arbitrator has not connected with the dispute, if there is any relationship of a husband with the tenant who happens to be the company, group of companies member of the disputant? So just a few say that she should be ruled out, should not be ruled out. The rest of us I'm assuming that the rest of you think that she should be ruled out. Is that correct? Unless you raise your hands, how would we know? So would you please raise your hands to say whether the arbitrator should be ruled out? You all think it should be. Most of you think the arbitrator should be ruled out. Another example. Take, for example, a share of a company, a public sector company, having a huge holding. If the arbitrator has some shares in that company, maybe 5,000 shares in a company which is listed with 100,000 shares, public listed company, and the dispute comes before him, would the arbitrator be disqualified? No. Again, if it was a mutual fund, so then judges followed that norm, and I'll give you my own example. Then judges follow that norm of announcing before the matter is taken up and telling the parties that, look, I have shares of X number, I or my family, in this company. It's a public listed company. The shares may be minuscule. Parties, if they have an objection, will please indicate so. If they do, the judge recuses herself. If not, the matter goes on. Sometimes the judge herself may not be comfortable with the idea of dealing with it, irrespective of what the counsels may say. And it happens very often. And then we record it and we transfer it out to another court. But that's as a judge. But would the arbitrator, having some share in a mutual fund in which there is a huge flavor of shares, including one in which there is an interest of a party in a dispute, be ruled out? The answer should be a simple no.
Disclose.
That's right. But in a mutual fund, maybe not.
The disclosure is necessary for the arbitrator.
Yes. And leave it to the parties.
Leave it to the parties.
Right.
That mandate is by section 12. In any way, relation.
Absolutely.
The quantity of share is not relevant.
But sometimes
he is a shareholder.
Yes, but Chief Justice,
of even one share, I suppose.
Absolutely.
So that's why the disqualification and disclosure are two separate
things. Yes.
So you disclosure and disqualification definitely
are different. So therefore, the discretion of the courts when entertaining such applications is to be exercised very carefully, not to mix it up. If there is no dispute raised or no issue raised, or if the arbitrator raised it and clarified it and went on, party can't later come back to court and say, look, I thought this was not the case. Now it is turned out matter is not going in favor of a party. So he or she approaches a court to stall the litigation. That is the purpose. We will now come back to the question that Chief Justice had raised when topic 3 was being discussed about segregation of disputes that are arbitrable and those that are not. Brother Sabyasachi, if you would just answer that question that was raised in the topic 3 of power to refer parties to arbitration under Section 8. If you've checked.
The Honorable Chief Justice.
Yes. Segregation of disputes. Of course.
In relation to, obviously not your question.
It's a public.
Obviously, I can be blown.
It's a public interest question. Yeah, we understand.
No, I feel, to everybody I'm saying that I feel, in my opinion, it may be correct. I wanted to stir a hornet's nest, actually. So because that Sukarna holding, that has not thereafter been explained as such. It has been kept at that it cannot be bifurcated. I say that cannot be an absolute proposition. There should be an evolution of that, in the sense that first we have to look to the principal relief sought in the suit. Now, because the principal relief determines what is the cause of action and what is the subject matter of the dispute before the suit. If the principal, suppose I claim a declaration, I raise a dispute regarding the partnership agreement. Partnership agreement has a clause regarding disputes on the partnership. I seek that declaration, that is the principal relief. On that, I seek an ancillary relief dependent on that if that is declared, then I declare that this. If the second relief is dependent on the first, in my opinion, we should go with the first relief, and we did not segregate anything. We directly send it to the arbitrator. And that question, whether they are related or not, the causes of action, that can also be left to the arbitrator under Section 16 also broadly. But where artificially causes of action are joined together. Like suppose I can't think of an example right now. Maybe I seek I seek a declaration regarding a particular, I seek a relief regarding a particular specific performance of an agreement. Regarding that agreement, there is an arbitration clause. And I seek a further declaration that somebody who has purchased subsequently, on the basis of that person, against that person I seek a declaration. Cancellation, if I seek, then it's subsequent, then it's related. I mean, the second one is directly dependent. I am saying of situations where those are not directly dependent. Those are different, rather different, but has a semblance of a similarity. I seek a declaration regarding a cancellation of an agreement, suppose, and I seek a separate declaration regarding the property involved in the subject matter or something like that. And I say that the second relief, that cannot come within the purview of arbitration, but the first relief does. So, as per Sukarna holdings, if we go strictly, like Order 7 Rule 11 principle cannot be partially rejected. Similar principle, it cannot be partially sent under Section 8. So that is to frustrate arbitration. Court has to see through that. Now, if artificially reliefs are joined, which are unconnected otherwise, then we can, I suppose we can use Order 2 Rule 6. We can think about using that these are unconnected reliefs. Part of it is directly covered by the arbitration agreement or related to arbitration agreement, and the second one is not. You have joined two unconnected reliefs. So this relief, one part of the relief, which is direct subject matter of the arbitration agreement, we can segregate the causes of action and can send in favor of arbitration.
Thank you, brother. There's another question that has come from Zoom. Shows that we have a very active online audience. The question is, what would be the test for a court to refer disputes involving non-signatories to arbitration? Again,
after Cox and King's, probably only test is conduct of signatories and non-signatories must signify that there is a common intention between them to make the non-signatories also a party to the arbitration.
Right.
That is the only test now.
In the context of Section 7 and what Justice Bhattacharya said,
you can sit and ask.
Group of company doctors doesn't fall in either of the two. Really speaking, frankly. And I don't know how far you can bring in lifting of corporate will can certainly be done.
Different.
But group of corporate doctors is a completely different thing. If not a signatory, how do you bring it in?
the question is,
Questioning the judgment.
the question is open to the House. If you all come across one, please deliver a judgment on what the question is. But he's posing a question right. So there is this. So there is there is this question that has come on online, which is which disputes cannot be referred to arbitration even if the parties have agreed to arbitrate.
Probably the last one, which I said,
There's a
with
decision of the Supreme Court.
Sorry?
Yes, 2025, yes.
Yes, 2025 2 SCC.
Yes.
Which explains Cox and Kings as well as Vidya Drolia.
Right.
It says that unless there is daylight, you have to just refer everything to arbitration.
To arbitration.
And then it's the call of the arbitrator.
And that is what the hands of
Ajay
policy.
Madhusudan Patel.
Exactly. That's, brother, so that is what the hands of policy is. That is what we need to emulate. Keep your hands off. Let the arbitral tribunal take a call. Then it comes to court. Then take a decision, not at that stage.
On segregation, I think that Justice Bhattacharya mentioned, there is one precedent of the Madras High Court in RK versus Tidal Park, where there was an investment in a captive generation scheme. So there was a shareholders agreement and there was a power supply agreement. And there were disputes under both. The shareholders agreement did not contain an arbitration clause. The power supply agreement contained an arbitration clause. A suit was filed combining both causes of action. The Madras High Court allowed a Section 8 referring disputes under the power supply agreement to arbitration while retaining the rest of it as part of the civil.
The shareholders part.
And this was, it went up to the division bench which upheld it. They went on the basis that in Sukanya Holdings, the language used is the cause of action cannot be segregated.
Not relief.
And therefore, since these are distinct causes of action, they can be segregated.
I've done the same thing, but I did not mention it for humility.
Possibly there is a contrary judgment of the Bombay High Court in Jindal versus Bellary, and the matter is pending in the Supreme Court for our learned
adjudication.
There is a contrary judgment of the Bombay High Court in JSW Steel, JSW versus Bellary. The matter is pending in the Supreme Court, but possibly the view which is taken not to refer identical context, shareholders agreement and an additional power agreement, because that Bellary was in the power business. So, but possibly the issue is now covered with a recent judgment of the Supreme Court authored by Justice Gawai in Zilon, which came from the Delhi High Court. So that would be the view which would possibly govern the Madras, also the Bombay judgment.
There's another matter which is pending in the Hindustan Oil.
Yes.
Yes. Distinct causes of action. And a party was also different.
Mr. Balbir Singh, you want to say something?
Original parties plus one more additional party.
Right. Go ahead, Balbir.
There's a
agreement. No, but would it
Zilon is the judgment. Zilon.
would it be distinct causes of action and the same parties? Because if it is going to be different parties, it may be different. But if it is the same parties, distinct causes of action.
Same parties, but one additional member, some more shares going to that party. And that second agreement forming part of the first agreement. Supreme Court says no.
Would that not be slightly distinguishable, sir? Because in that case, there would be a non-signatory to the arbitration agreement who would not fall within the...
That was the view of the Bombay High Court. So that is confirmed.
So there's another matter which is pending Supreme Court. That's a production sharing contract where the Government of India grant lease for exploration of oil and gas. So the lease is given to a contractor. Contractor enter into a further contract agreements with a multiple party, and they all sign to the production sharing contract. Independently, the parties minus Government of India signs a contract which is called Joint Operation Agreement. So the arbitration clause principle is there in the mother contract, but not there in that contract. So the dispute which has been raised is in the second contract where the Government of India is not a party. The question is, do you draw arbitration clause from mother contract? Because in absence of a mother contract, you can't have a joint operation agreement. So that's what is currently pending. Is going on.
There is one question on the screen.
There is another question which I'd read it out. I'll repeat it. We got very engaged with the earlier one, and it is an engaging question, no doubt. Which disputes cannot be referred to arbitration even if the parties have agreed to arbitrate?
This just answered.
Answered very we would not, yes.
There is one more category of trust.
Query is
gives that
right.
Trust judgment. There is a trust judgment. Trust also.
Another question is, are the provisions contained in Section 8 mandatory or directory in nature?
If satisfied,
it has to be mandatory.
And you're satisfied, the test is satisfied mandatory.
It has to be mandatory. The answer was in fact in what brother had discussed.
yeah.
Another one under section 16 of the Act.
Those three have.
Can an arbitrator consider lack of jurisdiction of the appointing court under section 11?
Covered by the.
I repeat, under section 16 of the Act, can an arbitrator consider lack of jurisdiction of the appointing court under section 11? Balbir?
No, in that case, they need to go back to the court.
Exactly.
Yes, correct.
I think
It
there's
is
only
the
one.
court that is
No,
appointed.
there's only one perhaps caveat.
That's true then, one,
In the case of group.
which are coming on
These
Zoom.
are the questions they are by the lawyers.
Yes,
So they are in fact arguing before you.
Interestingly, for the Chief Justice to know, interestingly, in one of our telephone, when we discussed on a
Yes,
VC,
Dalip.
so the judges had apprehension saying that don't ask us a question which we are already hearing.
Mr. Lai has a. I was only saying that in the context of group companies and arraying non-signatories as parties bound by an arbitration agreement, this is what a section 11 court is doing often now. Referring even the group company to arbitration and letting a section 16 arbitral tribunal decide whether it is bound by the arbitration agreement. So in some
Everyone.
cases,
Yes.
Once I fell into the trap of NTPC
Yeah.
and my judgment was set aside by the Supreme Court. After that, if there is an agreement,
refer.
go.
There is a April 2025 judgment of Justice Narasimha, which has a,
TPC,
no, it is
the needle.
Adavya project.
And even that has been
Adavya
diluted
project.
now. Even Eye of the Needle has been.
The needle is now diluted.
Is diluted in the
No,
judgment.
this is another judgment.
It's gone.
Possibly, which is a very good judgment, which has section 11, section 7, section 8 is Adavya projects versus Vishal structures 2025, 29th April it was delivered. 2025 SCC online Supreme Court 806. So it's a very informative judgment. Takes into consideration even Cox and Kings on addition of third parties.
So I think by and large, we've run through quite a few questions, those thrown by you now. Those through Sister Sunita Agarwalji. And of course, the Zoom questions that have come in. If there's still something we are now we've got literally 1 minute, we don't want to detain you. Truly, tea is well deserved by all of you. You've earned it. And we'd love to interact personally on a personal scale after we step out. If that's all, we will call it a day. We don't want to overshoot. It's just about 5 o'clock. So no more questions. Is that it? Thank you so much. It was really a pleasure to be here.
Thank you. Thank you so much.
We now request Honorable Mr. Justice A. Suppaiah to felicitate the fellow panel members. Starting with maybe request for felicitation of Honorable Justice Hema Kohli. And now request Justice Suppaiah to felicitate Honorable Mr. Justice Girish Kulkarni, Judge, Bombay High Court. Hello, Justice Suppaiah, may felicitate Honorable Mr. Justice Sabyasachi Bhattacharya, Judge, Calcutta High Court. Sorry to hold you for two more things, man. That's Mr. Balbir Singh. Lastly, if your lordships may kindly felicitate Mr. Ritin Rai. Thank you very much, Your Lordships, for this. Nah.
We extend our heartfelt gratitude to Honorable the Chief Justice, Srimati Sunita Agrawal of the Gujarat High Court, Justice Hema Kohli, former Judge, Supreme Court, for chairing the panel's discussions, my lords. We're grateful to the honorable dignitaries who participated in the panel discussion. Thank you very much. Thank you. Learned members of the District Judiciary and fellow lawyers, we look forward to hosting you tomorrow again. Thank you very much for your participation. Thank you.